We're going to call the meeting of the Board of Zoning Appeals to order and turn it over to our zoning administrator, Mr. Hargis.
All right. Good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of October 7th, 2021. I'm Joey Hargis, Metro Zoning Administrator, and I'll be presenting the cases for review in today's public hearing. Would ask if you've got a cell phone on you, if you'll put it on silent or vibrate or turn it off, even better, so as not to disrupt today's proceedings. The board is empowered to act on the cases before us and as outlined in Section 1740-180 of the Metro Code of Law. All cases heard by the board today will be considered. They will ask questions, vote, and discuss your case and make a decision today for you. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code does require that you have 4 concurring or yes votes to approve your application. And if in the event we don't have 4 yes votes, your case will be stay on our agenda for the next 30 days. And then after that time, if no one has changed their vote or no one that did not participate becomes eligible, and you still do not have 4 affirmative votes, your case will be deemed denied by operation of law. Board has published its agenda, and these are the cases that we'll hear today. I do have a few preliminary announcements before we begin. Board would ask anyone that wishing to address this board, if you'll come forward, have a seat at the table. Before you hit the buttons there, we have a little new microphone procedure. I'll come over and help you activate it there. But for cases with opposition, each side of the case has 10 minutes to present their testimony, and that's 10 minutes per group, not per person. So if there are multiple speakers for a case, be sure to divide your time before you come up to the table. But that's 10 minutes. The clock that we normally have that sits over by Ms. Davis unfortunately is broken, so I'm using the iPhone 9 as our timer over here. So I'll kind of make contact with you. I'll keep it up. If you look over at me, I'll show you how much time you've got left. So we're working on getting that repaired. So we'll be back for you. If you're here for a case that does not have opposition, you'll have 5 minutes to present your case to the board. It should be noted that if anyone's found presenting false or misleading testimony to this board that may have affected this board decision, your approval can be revoked at a later date by means of a show cause hearing. Mr. Chairman, I'll go through a couple preliminary announcements and announce too, the board does have a consent agenda. Prior to today's meeting, the chairman comes and reviews the cases with staff and recommends the case to other members of the board, and I'll call for those consent cases after this preliminary announcement. So, Mr. Chairman, the first announcement I have today on our agenda is case on page 2, case 2021-115, Fulmer Lucas Engineering at 924 8th Avenue. That case has been withdrawn. The applicant had requested some deferrals from the board. They were still working with their client to come up with a case. So because the deferrals have been so long since the original hearing date, I've advised them just withdraw their case and refile it when they're ready. And that way we'll get new notices out, new signs out, and notification to the public. So case 115 on page 2 will not be heard today. That is all of the preliminary announcements I have. As I said before, the board does have a consent agenda. And I will now call the cases recommended for consent. And if you're here in opposition to a case that's on consent, please raise your hand. Let me see you. Hadn't called any cases yet, sir. But I'm glad you're paying attention. If you're here for the case that I call, if you're here in opposition to the case that I call, please raise your hand. The case recommended for consent, I have but one today. It's on the top of page 3, case 2021-133. Stephen D. Travis and Donna Travis, the appellant and owners of the property at 628 Rochelle Drive, requesting a variance in the street setbacks requirements to construct a covered front porch. Is there anyone here in opposition to case 133? Okay, Mr. Chairman, I'm seeing none. That case is recommended for consent. We'll need a...
All right, there's one case that's recommended for consent. Is there that motion? Is there a second? There's a motion and a second. Is there any discussion? All in favor of that case, say aye. Any opposed? That motion passes, and that case is approved.
Okay, if you're the applicant for case 133, your day is short. You're free to leave. Be sure to follow up with the Codes Department beginning on Monday to inquire about obtaining your permit. And again, it's case 133 on Rochelle Drive. Mr. Chairman, I'll call the first case before you. The first case on today's agenda is a case that was deferred from 2 meetings ago and the last meeting, case 2021-116, Janine Thomas, John Thomas et al., owner of the properties at 2314 Seafried Street. They are requesting an item A appealing the zoning administrator's determination that this property is no longer a legal duplex in RS5, referred to the board under section 1740-650. Item B, the appellant has alleged jurisdiction under section 1740-180A. To remind the board, this case was originally heard approximately a month ago. There were only 4 members present at that time which heard the original case. That was Ms. Karpanek, Mr. Newton, Mr. Lawless, and Ms. Davis heard that case, and they are all present today. We deferred last meeting because we did not have all 4 of those parties present. In the meantime, as allowed by the board's rules, we sent a copy of the hearing from the last meeting, and I'll poll each of the 3 members who were not present the first time to see if you have watched the proceedings from last time and reviewed the file, and B, if you wish to participate. So the first one, I'll go with Mr. Cole. Mr. Cole, have you watched the tape in this case? He has not. Okay. Mr. Cole will not be eligible to participate in this case. Mr. Chairman Taylor, have you reviewed the record and watched the case in this?
I did.
Okay. Do you wish to participate in this hearing?
I will.
Okay. Mr. Taylor is eligible to participate. Mr. Pepper, have you? I'm not eligible. Okay. Mr. Pepper is not. So Mr. Taylor will participate. We'll have 5 members present. At the last hearing, Ms. Karpanek was acting as chair, and it mentioned that the hearing could be reopened at that time. And to you, Mr. Taylor, if you wish to reopen the public hearing to allow additional testimony. I do have a letter from Ms. Thomas that she's would like to submit.
I would if the applicant would come forward, and unless there's objection from the other people, board members that can participate, I'm happy to open the hearing for anything new that they would like to add. I think that everyone, we don't need to rehear the case because we all, I heard the case this morning, so I don't know if you need a refresher, we can have a refresher. Otherwise, if there's new information that the applicant would like to present, that would be fine. And then I know that one of the main issues was to get some information from our legal counsel, and that has been provided. So if my other board members agree, that's how we will proceed. So, ma'am, if you would state your name and address, and then I know that at the last hearing we said you would have to tell everything again, but what we really would like is just if you want to tell us what new information you have, and if there's anything that you want to add from last time that you weren't able to say last time, then that would be good to hear now.
Okay. My name is Janine Thomas. I live at 4217 Ashland City Highway, Nashville, Tennessee. My brother has written a letter, and I think you're just in receipt of it, saying that we are wanting to reinstitute the correct zoning for the duplex so that we can continue it as a duplex and also provide supplemental income for me and my brother when we retire. It was built as a duplex. It's always been operated as a duplex. The first unit, the front unit, is occupied by Miss Murray here, and she's been there for years. She was not ever aware of any notice being given to anybody about the property being rezoned when the blanket rezoning occurred. I'm trying to think, and it will be maintained according to my father's wishes, as is indicated in the letter.
Okay. Are there any questions on that? Did anybody have anything else to add that they weren't able to say at the last hearing? Yes, ma'am. If you would state your name and address and what you have to say.
My name is Myrna King, and I live at 2314A Seafried Street, and I have no objection to somebody else living there with me.
I'm sorry, what was your address, ma'am?
2314A Seaford Street.
Okay. So you live in the property that's in question?
Yes, sir.
And how long have you lived there?
Since January of 2002.
Okay. And sir, did you have something?
Yes, my name is Dan Lane. I'm a real estate broker, owner of ABL Realtor Services. And I think last time I talked about the blanket rezoning that took place in 2006 and 7 when duplexes became a dirty word in the city because everybody thought it was occupied not by the owners. And so there was a lot of blanket rezoning going on. I indicated that last time. The only thing I'd like to add is I also served on the Mayor's Task Force for Affordable Housing. And one of our recommendations was to make sure we made use of existing housing that was available, that may have needed some renovation or improvement, so forth. And I think this is a good example of we have a unit that can help serve our affordable housing need, and we should not lose it due to change in zoning.
Okay, thank you. All right.
Mr. Chairman?
Are there any other questions from the board? And did you all have anything else to add at this point?
I do, but
Okay.
I'll let their time.
Okay.
Yes.
No.
Okay. Mr. Hardy?
Yes, sir. Well, I was not present at the original hearing, so I just want to point out to the board that the rezoning is not the issue here. What the issue, the reason I've denied the permit for the duplex, the power for Unit B has been off since 2014. And the section of code that's being appealed is 1740-650B. It's the inactivity of a non-conforming use. Now, so I'll say for the record, I do not dispute that this building was built as a duplex. There's no question about it. The issue for us when properties rezoned from R to RS is this section, as it says, it's the inactivity of the use. And so what we asked folks to bring us are a copy of NES records. If we need more information, we ask for rental receipts and cancel checks and those affidavits sometimes. But generally, the NES record is what governs. And the issue and reason I denied the permit was the power in Unit B has been off since January 29th of 2014. So the code in 1740-650 says that the inactivity of a nonconforming use, when a nonconforming use has been inactive for a period of 30 continuous months, the land and its associated improvements shall thereafter only be used in accordance with this title. An intent to resume activity shall not qualify the property for a continuation of the use. And then for purposes of this subsection, the 30-month period gets told for two things. One, the flood of 2010, that tolling is moot now because the council gave a 5-year period. The second would be if this property was subject to litigation. For the purposes of this subsection, it talks about the use of the property as subject to litigation. And it specifically carves out litigation potential for estates or bankruptcy. Those are things that do not toll the 30-month statute. So in my case, the rezoning was only a portion of the question. The reason I denied it, because the power had been off since 2014. So.
Any questions for the zoning administrator?
I have more of a question for, maybe it's our legal counsel. Is there any option for us to, I know in the past, like with short-term rentals, for example, we ended up deciding something that the zoning administrator did not air, but they were allowed to reapply for whatever, for use as that. Is there an opportunity here where we could rule that the zoning administrator did not air, but that they could be allowed to continue or to reinstate the use as a duplex? Is there an avenue for that?
So I want to make sure I'm understanding your question. You're asking, can the board, I'm sorry, I guess I'm not understanding.
Right, because I believe that the appellant's case is that the zoning administrator erred in determining that it's no longer qualified as a duplex. So what I'm asking is can we agree? Can we would it be kosher to say that the zoning administrator did not err, but they would be allowed to use it as a duplex?
I need some time to research that.
Okay. Okay. Thanks.
I need to ask Joey a question, if I
Okay,
could, Mr. Chairman.
I'm going to, did you all, I think, had your opportunity. Was there anything else? I'd ask you before if there was anything else you wanted to say before we went to the zoning administrator, but unless you have something else to say now, I'm going to close the public hearing so that we can have our discussion. So I just want to make sure you have every opportunity to use your time as you would like to.
Well, I'm hearing that everybody did get a chance to watch the tape or listen to it so that they are aware that the reason why the property was vacant was because of life circumstances.
Right.
But there's no way in the world there's no way in the world that I could have continued. I had the strength to maintain the property during that time,
Okay.
and that was why it was vacant,
Okay.
because of that.
All right. Thank you.
Can I say one other thing?
Yes, sir.
The only thing I say, in that vicinity, if you drive in that area, you'll see where we're building two houses on the same size lot under the Horizontal Property Act. And to me, to lose an affordable unit because it did not meet the 30-month thing is not helping us in our affordable housing need.
Okay, thank you. All right, so I will now officially close the public hearing, and Mr. Lawless had a question for the zoning administrator.
Joey, when you requested proof of any NES stuff or tenant records or anything like that for the 30 months preceding, was any of that ever supplied?
Yes, sir. The NES records were supplied by the applicant.
And did it show two separate and distinct units?
It did, yes, sir. Both an A and a B with different meter numbers for each. Unit A shows periods of on and off, but no breaks in that for 30 continuous months. Miss King, who's sitting in the middle, her name is listed as the current tenant, with this power record being in her name since 2011. Unit B, the last tenant name listed is Melvin Samuel Brown, and it was on September 18, 2013, and turned off January 29, 2014, and no additional records in that. So
What about payment records from tenants other than Ms. Kane?
we haven't. I mean, generally the NES records are dispositive for us. I mean, if the power's off and they're renting a side without electricity, we have a problem anyway.
Well, but that's a whole different part of the code, isn't it?
It is, sir. I would attest that if I don't have power, I don't have activity, legal activity. So,
Understood. Thank you, sir.
yes, sir.
Are there any other questions for the zoning administrator or for our legal counsel? Okay, then discussion. I know that, when I watched the hearing before, there were, I think, some good arguments made. There's nothing about this property that makes me feel like it shouldn't be a duplex. It's always been a duplex. And what I'm trying to figure out is, how the zoning administrator erred, if at all, and is there a path for us to offer a verdict that would keep it as a duplex? And I'm having a tough time with that, in part because of what, the nature of the request. It's, did the zoning administrator err? And yet everything, I'm wanting to find a path. I can only think of a couple other cases in the 10 years almost I've been on this board where we've had this type of case. One, we did agree to allow a property owner to continue with the use after 30 months, in part because there was evidence of intent that it would be kept as that use. In that case, it was a car lot, and they were advertising to lease the car lot. And, there was just, the board found evidence of intent and agreed to do that. In a case that we've heard, I think maybe most of this board heard most recently was a duplex case where it appeared that the intent was not to use it as a duplex because it was a single-family residence, and the family that lived there said, no, we had only used it as a single family, intended it to be single family, and did that for 6 years. And so this board, I think, ruled that in that case it was not a duplex. So I don't know where that gets us, but other than back to my original thought that it would be nice to find a path here if there's a path available. I know that the legal question that we asked on the original hearing was, can we limit the use to this one owner, or, and the legal counsel came back and said, no, that we can't spot zone and we can't make that limitation, that in this case we need to decide was there an error or not by the zoning administrator in this determination.
I mean,
so I'm looking at the lawyer left on, or the two lawyers, the lawyers left on the board.
yeah.
For a path or a direction or a thought.
So I think this is a hard case, but I don't think the zoning administrator erred. I think this case is unique in the sense that we have a family-owned property, and it's been a family-owned property the entire time it's existed. And in this case, I have the people who still own it, who are a part of that family, saying, hey, we always intended for this to be a duplex. I think the mere existence of the structure as a duplex to this day expresses, in my mind, intent to keep it as a duplex. So I know that, like I said, I don't think the zoning administrator erred. I understand the zoning administrator's argument. If I was just going to offer a counter argument, it would just be like with the letter in support and the testimony of the applicant, and then the fact that I think this house was built in the 60s, and it has stayed pretty much the same, and it was used as a duplex up until the death of a family member. I do understand the timeline, but based off the testimony of the applicant, she was dealing with some other things and didn't realize all of the ins and outs of what had happened. So if I was going to make an argument, my argument would just be like the fact that we have testimony and a letter sort of indicating that this was a family property. It is still a family property. They want to keep it as a family property and just use it as it's currently existing. That's sort of the argument that I would make.
And so because of all that the zoning administrator erred in this case, not based on the historic standard, but we have to find that the zoning administrator erred or didn't err. And so if that's, and so that really is it. The zoning administrator either erred because or did not err because. And so the case would be, and your case is the zoning administrator erred because of those reasons. Is that right?
Yeah, I guess.
Okay.
I do, but he's saying basically
I'm saying that as an item A appeal, the only question on an item A appeal to this board is, did the zoning administrator err or not? And in the short-term rental cases that Mr. Newton alluded to, we could say that, no, the zoning administrator got it right, but we have the authority based on the code to define the punishment.
And he's saying we don't have the authority
And in
here.
this case, we don't have any authority to change the result. It's, did the zoning administrator err or not err? If the zoning administrator, if we find that the zoning administrator erred, then in declaring this not a legal duplex or a non-conforming duplex, it would still be a non-conforming duplex, then they presumably would be able to continue to use it as a non-conforming duplex. If we find that the zoning administrator did not err, then they would have to use it as the current zoning requires, or they'd have to go another route through SP or some other route to maintain its current use. Is that correct, basically? I always say that, and then I have to look to the person who really knows to make sure that I passed the test and saying where we were.
I guess, sorry.
No, that's right.
In my understanding of it, though, I mean, there is an owner of it, and whether or not that's her primary residence, or her family's primary residence, they have been there and continue to have a presence there to this day. And there is a second, and we have the actual renter of the other unit here also. And while that, the power hasn't been turned on at the second unit, it's still owned by somebody. It's still probably from time to time occupied by the applicant. Even if it's not their primary residence, it still has existed, and there's been two people either living there or renting the other unit. I mean, even though the power hasn't been turned on, it's continued ownership, and it's continued. I don't know if I want to reopen a public hearing, but if she's even been in that unit in that time, I mean, could the argument be made that that was, it was occupied in some way?
If there was any maintenance of.
Right.
Use. Yeah,
So, I mean, we have a continuous renter in the secondary unit. So that's, so, I mean, I think you're showing kind of a two-party use of the property, which would constitute a duplex.
And I guess your point too, like we had testimony at the first hearing that the owner didn't request NES to remove the power line. They just did it, and she didn't understand the implication of it. In this particular case, like I think 99% of the time, the standard that the zoning administrator used would work. But in this case, you're telling me if nobody lived there, but they just kept the lights on and paid NES $10 a month just to keep the pole, that would have indicated that they wanted to keep it even though nobody was living there. I just think, like, in this case, it's very unique. If there's other evidence to suggest that they wanted to keep it a duplex but just didn't understand the implications or make of other people's decisions, then I agree with Mr. Newton.
Well, and I did ask the zoning administrator, just as we all are able to ask questions about cases on our own, ask how the taxes were paid. Was it listed as a duplex? And Joey can tell us again, but it was my understanding that even though the zoning on the tax bill, is residential, it had as a description duplex, which in my mind would be evidence that the homeowner would not know that it had gone back to single family, and there would not be a signal to say, you got a problem or an issue. But is that fair from our record of our conversation and what you'd looked up, Mr. Hargis?
It is. I could expand on it if you asked me a question, but yes, that is.
Okay.
This is a unique question, counsel. What exactly is the standard of evidence submitted? Because clearly if we were in a court of law, there's more hearsay, inadmissible, dead man statutes. This is a bar exam question for evidence. Most of which I'd probably get wrong, but we'll just leave it at that. And just how much equity jurisdiction does this board have? I mean, we're getting into, and I haven't reached the threshold and haven't come up with the decision. Well, yeah, I have, but. And if you don't want to answer either of those questions, be my guest. I know what I want to do, but that's not maybe what I legally can do, I guess. And I think that's sort of what my question is. This is a heartstrings case, more so than anything else. So if I got some equity and I can play with it, that's one thing. But I'm not sure I do.
I'll be candid.
And I didn't mean to put you on the place either.
Yeah, And I would feel comfortable looking that up and getting an answer back to you guys. I don't know if we can set this for another date or if that's, to give me time to give you guys answers.
I may be outvoted anyway, so it may be a moot point, but if we don't have in this type of field, that equity level, and we just statutory, because I don't think the administrator made an error.
And I think that.
I know one vote only, and there's a whole bunch of us here that might say, well, it's nuts this time. Or it's just, we're gonna frame a result that legally I'm not sure would be sustainable, but that's also your department's problem at that point. So,
Yeah, and I think the standard is whether or not he acted in error when he made the decision. And, you know, unfortunately, I believe that is the standard.
I have a zoning question now. So if no one, who actually can occupy the second unit?
Currently, no one.
No one, so it's going to
Correct.
sit there, be unoccupied?
Yes, ma'am. Yes, ma'am. The zoning code, you know, in this section that we're dealing with, you know, I'll read it again. An intent to resume the activity shall not qualify the property for a continuation of the non-conforming use. That's, in my mind, is not ambiguous. I mean, and I have talked to Ms. Thomas. I understand the personal situation that's gone, but I read that sentence as I've got no flexibility, because you all have seen cases on the other side where we've said it was a duplex and you have neighbors saying it's not a duplex. They didn't use it. Yeah, the power was on, but nobody lived there. So that's kind of where we are as a department. I've got to just set that standard that we start with NES records, and if the power is clearly off for 7 years, in my mind, that use is gone, regardless of the situation that got there or how it became empty.
So could the second unit be used if family members occupied both sides?
Yeah, the way to go, you're essentially have to convert it to a single-family residence. Take out the firewall between it, and remove one of the meters and sort of wire that side with the other so it's running off one breaker box and one service.
Could one side be an accessory apartment? Because that seems to allow family members to live.
It would, as long as it conformed with the provisions under accessory apartment, limiting the size and scope of it, and the proper covenants are recorded. That is a possibility.
Okay.
The accessory apartment does allow its own service, but coupled with that, we require the covenant. So when we look at these records, we see, oh, there's a second meter, but here's a covenant and a permit that says this is for accessory apartment only.
Any other comments, questions, or thoughts, or a motion?
I guess my only thought is I don't want to make the applicant come back here again. I mean, she's already come back 3 times. That's my only comment there. I'm trying to think through how it would work to not make her do that.
Yep. Well, and I do think that each of us are, well, I'll speak for myself, and I think it's what I hear from a lot of the other comments is that, you know, and Tom said it too, what we would like to see happen, we're trying to reconcile with what we can make happen based on the authority that we've been given and the rules. And that is why I think we spend a whole lot more time on this than on this case than we would spend on similar cases, because I think what we're struggling with is really trying to find a legal path that we can take to help the applicant, and it's not clear to me, and I would love for it to be clear, and so that's where I think we all are, and we need to, I guess, either find clarity in that path, or at least make a stab at clarity at that path. And everything that's been said to me strikes at fairness, strikes at how it should be used, how it was thought to be used. I get all of that. And not sure exactly how I would side if it came to that, because I know how, but again, back to to our legal counsel's comments and then the zoning administrator's comments, I think there's been consistency in those across time too. So we need a path, or a path one way or a motion the other. You know, and then the other, and again, if you feel like that there's a,
So
and I
it
guess
seems like
that-
everybody's hesitating. I'm going to go ahead and do it.
Yeah,
I
thank
can
you.
distinguish this from all the other
Thank
cases
you.
because we had testimony in those cases that it wasn't being used. We don't have any testimony here that, contrary to her testimony. Like in those other cases, we had testimony from people saying that they weren't using it as a duplex. Here, we don't have any evidence other than the evidence presented by the applicant. And based on the evidence presented by the applicant, I move that the zoning administrator did err and that the use should be reinstated.
I'll second that.
Have a motion, have a second. Is there any discussion? All right, all in favor of the motion, say aye, raise your hand.
Aye.
Any opposed? That motion passes 4-1. Mr. Lawless,
Thank you all.
best of luck to you, and we will hear the next case.
Okay, Mr. Chairman, the next case is case 2021-124. This case is a holdover from the last case. Sorry, let me get my agenda here in front of me. This is Ken Sardash, the appellant, Brian Sharp, owner of the property, 2955 Nolensville Pike. He's requesting a special exception in the street setback requirements along Timmons Street in the CS district to construct a 20 by 40 addition to the side of the existing auto sales repair business referred to the board under section 17-12035. The appellant has alleged the board would have jurisdiction under section 1740-180 item D. To recap, members of the board, this case was heard. You did go through the public hearing. We took testimony on both sides. During the hearing, I told the board that we would need to postpone action on this until the applicant held his neighborhood meeting as required by your rules and affirmed by court that you must hold a neighborhood meeting for a special exception. I would like to call him forward to at least testify on the record that he did hold the meeting and an outcome for it for your purposes. But whether this board wants to continue additional question is up to you all to decide. So,
Okay, is the applicant present? Is there any opposition present?
yes.
Okay.
All right, Mr. Chairman. Sir, if you'll come forward as the appellant, again, the public hearing at this stage remains closed. I'm just going to show the board members photographs to refresh their memory from the previous case, but if you'll come forward to the table up front, sir. Again, if you'll recall, the portion that the special exception was for this gray roof carport portion. These two structures do not have permits and need them, but would otherwise comply with the setbacks. And that is the extent of the case record. Sir, that I'll help you there. I'll help you with the microphone and get you started. But, Mr. Chairman, I guess the only question for this board is, did you hold your meeting? What happened? And if you wish to open it further, that's up to you guys.
All right. We're going to get your microphone on, and then you can tell us about your public meeting. All right, sir. Yeah, if you would, again, state your name, address, and tell us about the public meeting.
Yes, sir. Hello, Mr. Chairman, Chairman Taylor, and members of the board. My name is Keon Sardash, and I work at 2955 Nolensville Pike, Nashville, Tennessee.
And did you have your public meeting?
Yes, sir. We had it yesterday.
Okay. And tell me who attended and what you discussed and what the feedback was.
Two of my neighbors showed up, and we had an open discussion about what was going on and what we were trying to do. And we even talked about some of the concerns they had at the last meeting and what we've done to address those concerns. And overall, I think it went well.
Okay.
I handed out pictures. These are pictures I took yesterday. Again, we're a small family business. It's just me and my dad that run the shop. What we're trying to do, when you see a little awning extending from the garage, that's all we're trying to do is keep that 5 feet of awning. Now, my building permit application, there must have been some type of mix-up or something that says I'm trying to add a 20 by 40 foot addition. I've never done a building permit before. This is the first time. I don't know if it was the guy that done the survey that wrote that, but we're not trying to create anything new. Nothing new is being built. We're just trying to keep that. We're trying to get a building permit for that garage that was there before we started renting the property. But my building permit, my zoning is being denied because of the street setback on the front. It needs to be 15 feet instead of 9.44 feet. I'm here to see if we can keep that awning because it really helps out with the garage. When it's raining hard, a lot of water comes in, and just that awning, it really helps a lot.
Okay.
To keep the rain out.
All right. Was there any other questions from the board? I need to ask the board too. We'd add it was deferred, as Mr. Harger said, just to have evidence of the community meeting, and that evidence has been presented. We did get some pictures from today. And we've had people that want to come and speak. I don't have a problem with people that didn't speak last time having a say, at least, unless you want to open it to have a full additional hearing.
Mr. Chairman, my only concern is that we heard there was community meeting, it, quote, went well. Well, going well can be interpreted a lot of different ways. Right. So if anybody happens to be here that was here last time, because some of them were
That's right. So
pretty vocal.
So you would prefer to just open it back up and let the other side have...
Just the events around the community meeting, and was there a shift?
Okay.
I agree. I think also since the applicant just talked again.
No, that's fine. That totally is fair. Okay. Sir, if you would have a seat, and then anyone who is at the community meeting in opposition who wants to come and speak will have an opportunity to talk about that community meeting. So were any of you at the community meeting? Then then please come up and state if you'd like to speak, state your name. Only if you were at the community meeting. That's what we're here to.
I'm representing my neighbor who was at the community meeting. That's fine. Is that okay?
Yes, sir. All right, so sir, if you would have a seat, and those folks who can speak directly to the community meeting. All right, come on up. All right, sir, if you would state your name and address and what the information that was passed on to you to represent.
My name is Chris Saunders. I live at 519 Timmins, and I'm representing my neighbor, Grant White, who lives at 505. Grant was at the last hearing. He went to we only got the invitation to the meeting on Monday night, so most of us only had 1 day's notice, which is why it was underattended. Grant went, Emily went, and I realized the mandate of the hearing is only on zoning. And last time we presented all kinds of things which were not relevant. But I did rewatch what we did last time, and it was the hallmark were inconsistencies where the applicant claimed things and then contradicted himself in the hearing. The same thing happened last night. They said they're not going to build a new building. Well, once you approve the setback, we have no guarantees that wouldn't happen. and it's a tremendous traffic hazard. And as I said, I don't want to go outside the mandate of the meeting, but I guess where the neighbors are confused is how it's possible to have a legal decision on unpermitted buildings and code violations. I would have thought that that stuff would have had to been addressed before something like a setback would be.
Right, well, as it was, I thought, clear in the last hearing, there are two buildings in question which are not in violation of the setback and which are not before us. The only thing that is before us is the, I think, what do we call it, a lean-to, the shed.
Yes.
The shed roof that was added, and 6 feet of that shed roof is outside the setback. If that shed roof were 6 feet shorter, we would not be here at all, period.
Well, I guess the question is, I'm sorry.
Sir, I'm not done. And so that's why we're here, right? We're not here to talk about whether they had a permit or not. That's not relevant to us.
I totally understand.
It may be important to the neighborhood. It may be important to the city. It is not important to this board in terms of what we're having to do today.
I guess, I'm sorry. I guess it was a legal question for Mr. August.
Right, but this, all right, so.
Which I'll ask him later.
Yes, sir.
Because I'm not clear on that, but I guess permits, setbacks are worked out by city engineers. They're there for a reason. I don't think a compelling case was presented for that, and that they have other options. They could build higher. They can go up to 30 feet. I don't see there's a compelling reason to change that.
We're kind of getting outside of what happened last night.
Right.
So, and I thought that's what you were limiting us to.
Right. Ma'am, did you have something that you'd like to say?
Yes.
And you were at the community meeting.
Yes, but a lot wasn't discussed there either that we need to. But I'm Emily Richardson. I live at 507 Timmons, and have for 6 years. I understand who do we talk to about the permit, but that's not you all. The issue is that they built this building after they started the business. When they sent things out to us, they have drone pictures. You can see before, it was not as big of a business then. And they said, we didn't build it in 2015 when they took it over, but they did, because it was after in 2017 when it was built. And the street thing is huge. I don't know if have you driven by it? Have you seen the actual space, or?
That's for you to testify to us, not to quiz us on.
Okay, well, it is an eyesore.
Tell us what you see on the street, not quiz me whether I've seen it, because we did see lots of pictures that caused a lot of concern at the last hearing, and I have new pictures that are a whole lot cleaner. So you tell me what you see and testify to your experience, and we will interpret that as we are to do as a board.
Okay. In addition to just the street traffic and how dangerous that is and how annoying it is, I'm almost hitting people all the time. Yes, last night they did say we've tried to get it better. But as you see, also, their business has expanded, and that's a great thing, and I support that. But it has gotten to the point where there is not enough room, I believe, for this operation to continue, and it will continue expanding. They told me last night they're already renting an area for more cars. And another thing that I believe is really important, I don't know if y'all have anything to do with this, but that they're working on cars, I believe. First he said he didn't last time, and then he said, when we work on them, they are only licensed to sell cars. This garage that they did build has a lift in it, and it's going to they're also building houses directly across that did just get approved behind my friends who live there for 4 houses. There's no more parking area for that. I mean, it's going to be a, you know what. And I'm not trying to say, completely get out of here, but it is an eyesore, and I support them, but I don't believe the property is, good for them anymore. And so I know now they're begging, to keep it and to do it after they didn't have a permit, and I don't think that they may not care what will happen next. You just give them their awning, and then who knows what else.
All right. Questions for the
I think
opposition?
he was there first,
During the public meeting, again, we're trying to keep focused on that. steps did they claim to take to alleviate some of those issues that you're describing? Or did they offer anything to alleviate those issues?
Yeah, all they said is that we are telling people they can't park in the street anymore, the tow trucks can't be there, and they asked us, has it gotten better? And we said, yes, a little bit, maybe in the last 2 weeks. But the operation they're doing, and it's been 5, 6 years that I have seen it, that it will not continue to be. Something else will happen, I'm sorry, or we will find something else.
Within the last 2 weeks, since our last meeting,
Mhm.
obviously they're trying to do the right thing because they want to get support to have this passed. But it has gotten better. You can't testify that it has improved over what it was, but it's still not. But you would testify that it's still not to the level that it doesn't. It still endangers the pedestrian welfare along the streetscape.
Oh, yeah. I mean, I turned the other day and was head-on to a car, and she just kind of said, sorry. And I'm like, I've almost hit people so many times, Joel. And there's a blind spot because of where their cars are that they're saying they're selling. You have to have that curb thing. And, once they're going to, it's just going to be very, very tight. And it's not what I want in a neighborhood where we have now improved it, in a lot of ways. Our houses are, value going up. It's a nice area, and I do not like it. Sorry.
Have you had an opportunity to look at the pictures that we were presented today? Have you guys seen them?
Yes.
No,
Yes.
I mean, I don't mind handing you my copy, but, okay.
No, I haven't.
I have not.
You're more than welcome. Is this representative of what is out there now?
No.
Okay. And was this discussed last night?
Regarding the meeting, the hearing here was on September the 23rd. Had the invitations gone out then, we would have had several weeks to coordinate attending the meeting. As it was, we received it on Monday night. We had 1 day's notice.
I understand the short tenure, but I'm just basically trying to limit exactly what we're dealing with today's testimony and things. So
I guess the word I'm looking for is contrived.
So if I was to go tooling by there right now,
yes,
or if Mr. Hargis was kind enough to have his drone go flying over the building, would it look like this?
No.
Okay. So, and am I hearing correctly that the testimony that you heard from the proponent or the requesting, and this board is kind of like, oops, we made a mistake, would you give us forgiveness? Is that a nice way of declaring us a lot of times? Yeah. Okay. At least in my opinion, that happens. Are you saying that you question the truth and veracity of the proponent?
Exactly.
And you're indicating yes for a record?
Exactly.
Okay. That's all I...
All right. Are there any other questions for the opposition regarding the community meeting or what was said or might not have been said? All right, thank you. And we can hear back from the applicant. All right, we're gonna hear back from the applicant now because we've addressed and answered the questions for the community meeting.
Okay.
And again, everything that was said at the last hearing by both sides is still on the record and very much in the minds of the board. So if you all will have a seat and we'll hear back from the applicant.
Can I say one more thing?
No, ma'am. All right.
Yes, sir. I truly feel where my neighbors are coming from. The city is expanding very largely. Streets are getting busier. I mean, just off that little side street where I'm at, I'm not the only business. It's 3 other businesses. That house that you see right next to my roof shed, that's another car dealership. Right across the street is a Title Max, whatever, and a restaurant. So that's 4 businesses in that little side street. Me and my father, we've done a lot of measures. Like we've talked with the managers of O'Reilly's, AutoZone, Ed Advance, close to us. We told them use the other entrance. We really want to keep our neighbors happy. We're a community. They live here. We work here. We probably see each other every day. You know, we have to work together. We can't just. So I put no parking signs up on the dumpsters. Any person that comes over there, we tell them move, use the other entrance. We're trying very hard to, you know, clear it up as much as we can. Yeah, 4 duplexes are being built right there too, so that's going to be even more traffic. And I really see where my neighbors are coming from. I feel for them. I don't like the traffic either, but then again, we do have a business to run. I mean, it's just we're not a huge corporation taking over the neighborhood. It's just me and my dad. That's it. Another thing, yeah, like there's a furniture store right in the block over that just got bought out. 800 apartments are being built. That $399 furniture place, being 800. So the traffic is going to get worse and worse. But we've done everything we can to keep that area clean. And but yeah, it's, I mean, if you can see from the pictures, I mean, all we're trying to do is just keep that awning. Even that stoop and the railing is going out further than the awning. Now that what it looks like a sidewalk, that's not a sidewalk. It's just that level is as flat as the street, and people get comfortable with parking right there. That's why we always have to go out there, run out there, tell them, hey, don't park here, don't park here. But it gave me a sign of relief.
Can I ask you a question?
Yes, sir.
You say that's not a sidewalk, but isn't that just the apron that's part of the sidewalk? I thought that was part of the sidewalk.
The sidewalk ends right there. The sidewalk doesn't go into the local street right there. It used to be a burger spot, like a drive-through burger spot 20, 30 years ago. I don't know why. So it's like easy for cars to drive right onto. No, you're fine, sir.
Okay. Any other questions? Anything else to add?
I mean, we're in the 5 years we've been there, we never received any criticism from my neighbors. They never came and said anything to us. My first time ever hearing that my neighbors were unhappy with us was 2-3 weeks ago when we were here. But again, we're open to criticisms, and we want to help. We're a community. We have to work with each other. We can't just go by day to day, not ignoring each other. Yeah.
All right. Thank you.
Thank you.
Can I just ask one question, since you did go a little bit far afield? How many folks do you have employed there?
I have 3.
Three other employees besides for you and your dad?
Yes,
So you got a
sir.
total of 5 employees?
Yes, sir.
Okay, thank you.
All right. Any other questions? We will close the public hearing. Well, all right, so, we do have a letter from the council member, which was redated to October, stating her continued opposition to a setback variance or setback special exception. And I mean, there's a lot of conversation about, again, in the last case and in this case too, and often in many of our cases, of what we're really here for. And, we're not here to, talk about buildings that aren't, on our docket, however they came about, and however irritating they may be, and I get that they may very well be. When I look at, the past pictures, the pictures that were submitted at the original case, we even said this at the last hearing, that there was evidence of not being the best neighbor by any stretch. I think the pictures that were submitted to us, which the neighbors have testified don't represent what they see even today, show being a better neighbor. In concept, the 6-foot variance isn't to me very offensive, other than I think Mr. Newton had mentioned at the last hearing, how it would encourage more parking and cars in the area where it's a problematic for safety from the neighbor testimony and from walkability and that type of thing, which I think was a key factor in the special exception criteria. And so that, you know, I mean, when we look at it, as we're only looking at this shed, and how that shed impacts the sidewalk, you know, to me, the only path for approval to me is if, you know, all of that land that we see between that red truck on this picture and the road were hashed in yellow with no parking, and that was, you know, fully enforced. But I don't see, other than that, I don't see long enough evidence to say, yeah, this is going to be a clear path. And yet at the same time, it's, you know, 6 feet on a shed. What is everybody else? I'm just yapping, waiting for somebody else to hit their red button.
I was going to ask
You should
Mr.
have thrown something at me, Ross. I'm sorry.
I remember Mr. Newton talking about, I mean, I didn't like the way I think we had to do this hearing twice because the applicant didn't do it right the first time. And it does come down to this overhang. And my first look at it was, okay, I don't know how that's really going to affect the neighborhood, but Mr. Newton, who's an architect and knows more about these things than I do, I think his position was that it does encroach more into the public space, and so I was going to hand the baton to him and ask him to.
Okay. And yeah, well, yeah. I mean, so the biggest issue I see with the overhang being where it is it encourages cars to be out in front of the shed, which when cars are out in front of the shed, they're literally probably hanging over the right of way. I don't know exactly where the right of way is, like based on these pictures, but I mean, these vans that you see are up tight as they can go, probably maybe even halfway into the garage. I can't tell, and they are barely even off the sidewalk. So if they didn't, you know, I don't know if the applicant took these pictures or who took them, but if they hadn't pulled all the way up tight, and you know, it didn't help them actually. It still didn't help them that much. They're still almost in the sidewalk, and I do see a pedestrian safety hazard. I see a traffic safety hazard for car. I mean, I know that stretch of Nolensville Pike pretty well. I mean, you're going 40 plus miles an hour along there, and then you're trying to turn, and there's no, I don't even know if there's a center lane, right? That there may be, that is regardless, but you're turning onto a lower speed residential street, and there's cars blocking your view as you're coming around that corner. I mean, I think that is a potential safety hazard. You know, I appreciate the applicant. I think he's, you know, spoken well for his case. I think that at the end of the day, it does provide a safety hazard.
Well, in addition to it being a safety hazard, I think we need to see some type of hardship, right?
Not in a special exception.
Okay, because I'm definitely not seeing a hardship at all. And I do agree, Mr. Newton, that I believe this awning is pushing activity towards the street and sidewalk, and it's a safety hazard.
And just, I mean, I'm not a civil engineer, but I mean, and I don't want to speak for Public Works, but I mean, I can tell you that this whole curb cut all the way along this street would never happen today. And I think that if you're changing the property that's already non-compliant to be even more non-compliant in terms of that, I think that's an issue. You're not moving it toward compliance. You're moving it away from compliance with any current standards with this setback.
Right. So, anybody have a motion?
I'll move that we
Hit your mic.
I will move that we deny the application.
The special exception.
I mean,
There's a
the
motion,
special
is there a second?
A second.
There's a motion, there's a second. Any additional discussion?
I just have to not participate because I did not watch the tape. I didn't realize there was a public hearing before the deferral.
Okay. The motion is that, is to deny the special exception. Any other discussion? All in favor of the motion, say aye and raise your hand. Those opposed? That motion passes 5-1. All right, next case.
Okay, Mr. Chairman, the next case the board will hear is case 2021-131. Get my screen to come back on. Here we go. Great. Bo Brady is the appellant, Dental Specialty Holdings, LLC. The owner of the property is located at 447 and 451 Murfreesboro Pike, requesting a special exception in the height requirements in the CS district to construct a mixed-use apartment complex. Referred to the board under section 1712-060F, sorry for the typographical error there. The appellant has alleged the board would have jurisdiction under section 1740-180, item C. Is the applicant present in case 131? All right, sir, come on forward and have a seat. I'll turn it over to you. Are there any parties present opposed to case 131? Mr. Chairman, seeing none. Sir, when I turn it over to you, you'll have 5 minutes. Again, I'll keep time here. Just glance over to me. I'll show you how much time you've got left when we get to your portion. The subject property or properties are these two parcels located at the southwest corner of Murfreesboro Pike and Spence Lane. In just southeast part of town. Again, a view of the subject properties here. These are ground shots of the properties there. Views along Murfreesboro Pike in the upper left photograph. This is looking south away from town on Murfreesboro Pike. This photograph here is from the other side of the street, facing south as well. And then a view sort of south and west on Spence, where it crosses over. This is the site plan as submitted by the applicant. In my determination of reviewing on this, I declared that this parcel boundary to on the southern portion where you see my cursor following is the rear line of that. So in that case, this is the special exception portion and exhibit submitted by the appellant of the portions of the structures which violate the sky plane at the setback in the height control plane. And then a view of the proposed development. All right, that's the case as we have it. I'll leave it here. I'm happy to change to any other photograph that you all need me to or the appellant needs me to. And sir, with that, I'll turn it over to you. You have 5 minutes to present your case to the board.
Yeah, if you would turn your mic on and state your name and address, and then
First button on the right-hand side. There you go.
Can you hear me?
And then, yeah, and after you do that, tell us about your community meeting, because I've gotten our board in trouble with a couple of cases by not asking that when they didn't happen after we'd heard the case. So let's make sure you had your community meeting. You can tell us about that and then tell us your plans.
Yes, my name is Bo Brady. I'm with Southeast Venture Design, representing the owner, the architect for this project. Give me 1 second. We did have a community meeting on the 15th of September at the subject property, and we had just two local neighbors come by to get some more information on the site. One was our neighbor directly to the south with Allie Cassidy, just trying to get a little bit more information on it. Seems to like what we're doing. He seemed in full support. And then the other gentleman owned a car wash down the street. I don't know how far away it was, but he was excited about the development as well. So we didn't really have any negative feedback whatsoever. I think they were both in full support of some new development along this corridor. Real quick, I'd just like to say that we did receive notice yesterday from planning that they were in support or approval, and then we do have some email from our council member Sledge, who said that he was in full support. I don't know if he actually sent a letter or anything, but we do have email confirmation of that. Yeah, the reason we're asking for this request was, one, we have somewhat of a constrained site when it comes to the existing curbs and existing conditions. So we tried to maintain the existing curb cut on Fessler's towards the south just to keep it away from the intersection and not try and introduce a new one along Murfreesboro. That's something Public Works would probably agree with, and they would recommend. So that puts us more towards the south end of the parcel to locate all of our on-grade parking, and then trying to respect that 15-foot setback at the street along Murfreesboro and Fessler's. That really only leaves us with about like 80 feet to locate a building footprint for a typical mixed-use building. And then we also have, I don't know if you can see it quite clearly on that site plan, but we do have a sewer easement running along the south parcel, and it terminates towards the middle of the property, but it's running perpendicular to our current building layout. That's just another reason why we can't really shift this building back and relocate parking towards the north, just because we can't build over it. And then another point I'd like to make is that, the current CS zoning, it's somewhat limiting the height to 30 feet, and then with the control plane pushing it back further. And what we're trying to do is follow what the South Nashville Community Plan is looking to achieve, which is under I guess it's the T4 Urban Mixed Use Corridor. They're trying to hit 3 to 5 stories, add more density, more height to this area. They even mentioned that at like key intersections like this one, it's more of like a central node to the corridor, and they want to see even more height. But we're only asking for 5 stories here, and we think that there's just some contradictory nature of the current CS zoning and then exactly what the South Nashville Community Plan is wanting to achieve. So I think we're designing something that planning and the city and our neighbors are wanting to see to kind of promote more development along this area. Yeah, I think that's it.
All right. Any questions?
With a special exception, really what's before us is whether or not this proposed building will have an adverse effect on the neighboring properties in terms of pedestrian experience and light and shadow. So can you speak to the property that's next to this? I forgot what it was, but we might be able to see it in the photo, but that's what we're really looking at with a special exception.
As far as just...
Will this new building have an adverse effect on the property next door in terms of it, casting more of a shadow on that property or impairing air on that property? There's a list of things we need to look at in the special exception section.
Right. No, I don't think it would. The building is only 70 feet in depth, and it's pushed up towards the street, up towards the frontage, which is something more of it brings, more of a pedestrian friendly feel to it. It feels more walkable. So I think it's promoting more of like a street scale that this area is wanting to achieve. And, the height is within 5 stories. Like, I don't think we're trying to do anything extremely high where it would have an adverse effect on light to the neighboring building, based on its orientation.
Joey, could you flip up the proposed, the views that we had of the, yeah, thank you.
I wanted to know, so they're asking to encroach the 30-foot height plane, and you keep saying it's a 5-story building. How much of an encroachment do you anticipate making with this proposed build?
Does this show right here?
Yeah, it says 20 foot, so it's encroaching 20 feet in height from the existing 30 feet allowed in CS zoning.
But it's only the red part that is really
correct
against code. If you'd stepped it, it would.
Yeah, if you stepped it, it would do that. But by doing so, you're limiting the overall building efficiency, and it almost makes it not achievable to do the project when you essentially lose those units along the front end.
Right.
I think we could get clarification on that from the zoning department. The 30 feet requirement is at the street setback only. The entire building is not required to max out at 30 feet, is that right?
Spoken like a true architect.
Yet the maximum allowable setback at that, maximum allowable height at the setback is 30 feet in CS.
And then that's where the control plane starts to come into play at the 30 feet.
It is, and then for every foot you step away from that setback, you can go up an additional 1.5 feet in vertical. And that's what he's depicting here, is that the red area would be that plane.
Any other questions for the applicant?
Do you know what the right-of-way on Murfreesboro there is? The width of the right-of-way?
No, I know it's definitely increasing due to, it's considered a multimodal corridor now.
Right.
So they're trying to promote more transit and they're increasing the right-of-way, which is pushing our building and constraining our site a little bit more.
Right, so the developer of this is dedicating right-of-way to the city, and that's hurting your skyplane issue in the first place.
Correct.
Okay, thank you.
Any other questions? Anything else to add?
No, sir.
Close the public hearing. I think it's a pretty great project for Murfreesboro Road.
Other than the fact that it's getting rid of one of the last vestiges of Mrs. Winter's chicken in the city, but I think,
I haven't heard any.
Text on this, guys.
Yeah, I haven't seen or heard anything that would give me pause to think it wouldn't meet the special exception criteria, and the planning department would also be an indicator of that, and they support it. I don't see Councilman Sledge's letter in our packet, but I trust that that's accurate too. That I think it's a pretty great project.
The only thing that really gives me pause is the pedestrian experience. You know, it's a really different feel, you know, walking along, you know, a 3-story building versus a 5-story building. And based on the plans we've seen, you know, I could see if there was a retail experience along the street, but these are really just apartment units, right, on the first floor.
Can I speak to that?
Yeah.
We actually have commercial space located on the ground floor, and then some additional along Fessler's as well. So it's a mixed-use building. It's not just apartments.
Okay.
I'll reclose the public hearing.
Sorry.
No, that's all good. Yeah, I think in everybody's mind we knew where it was going, and it's all fine.
Sorry about that.
And I'm glad that Mr. Cole brought that up, because I understand that this is a nice project, but I don't think that dedicating the public right-of-way is the only reason why this happened. I think part of the reason is because it's 0.69 acre of a lot and you're putting 100 apartments on it. So I don't think it's just, that they dedicated right-of-way. It's also because of the scale and the size of the project.
Other discussion?
Yeah, I do agree with that, but I think as the planning department analysis showed that the size and scale of this project is what should be going, or what the planning department and with input from, you know, neighbors or National Next and all that kind of stuff, what they've shown they desire for this area to be of this height. So I agree that it is it's more than the current zoning allows, but it is as planning department noted, is in line with the with the overall planning plan.
Any other comments or discussion or a motion?
I'll just say they're allowed to have 5 stories. I'm looking at on your computer there. It's only a portion that they're not allowed to have. And if they meet the intent of the special exception, then they are actually allowed to have it. And I don't see how they haven't met that, like the chairman has
Is that
mentioned.
a motion?
Yes, I will move to approve the special exception request.
Is there a second to the motion?
Second.
Mr. Pepper, any further discussion on the motion? All in favor of the motion, raise your hand and say aye. Those opposed? So who was opposed? All right, and everybody else was an aye, so that motion passes 5-1, or 6-1, sorry. All right, next case.
Thank you.
Need a quick break? Okay, we will take 5 minutes. Just 5 minutes, please, and get back and hear the last 3 cases.
Board will be in recess. This is case 2021-134. This is Jeffrey Woods, the appellant owner of the property at 4501 Dakota Avenue.
Hey, Joey, we've lost our video.
Turn again, sir. Oh,
We've lost our video.
sorry about that. There we are. Should be coming back there. Mr. Woods is the appellant owner of the property at 4501 Dakota Avenue. He's requesting a variance in the side street setbacks in RS 7.5 to construct a sunroom addition. Mr. Woods, are you present? Good. If you'll come forward, please, sir. Have a seat at the table. Are there any parties here opposed to case 134? Mr. Chairman, I see none. Mr. Woods, you'll have 5 minutes. So after I get done with my portion, I'll turn it over to you. Again, I'll keep the time over here. Just shoot me a glance or ask me how much time you have left. I'll give you a 1 minute warning. So when we get close, the subject property is located on the southwest margin of Dakota Avenue in 45th. This is over in the Nations area. This is again the subject property here by aerial photograph, and the request. In this north would be at the south bottom of the drawing here. The request is to construct this sunroom addition located in this blue-green area here. The zoning code requires that corner lots created prior to January 1st of 98 are allowed to reduce their side street setbacks in half, which in his case would allow him to do a 10-foot setback. He is requesting to be 6 inches from the right-of-way on 45th Avenue. That's the variance location. This is the area in which the addition, now you may look at me and say, there's a lot of grass here. 45th has an extremely large right-of-way. I will bring up the parcel viewer to show you that. In the Nations, there are many lots in which, at the time it was developed, envisioned streetcars running through this neighborhood with wide right-of-ways. Obviously, technology progressed faster than the neighborhood did, but those right-of-ways still remain. So this is the area for the addition where that would come off toward 45th. And then views looking south on 45th, Dakota is on my right-hand side. This bottom right photograph is facing west on Dakota. And then I'm at the corner of 45th and Dakota, showing the addition would come off the side of the home here. As I talked about just a second ago, let me pull up the aerial parcel viewer maps for this neighborhood. Get some of this out of your way. But if you'll note, over in the Nations, we have fairly large rights of way here. So in this case, for instance, the right-of-way on Dakota is almost 100 feet wide there. So that's a little wider than Old Hickory Boulevard in some places of our county. But so we do encounter this from time to time in our office when a homeowner comes to see us to put an addition on their house and are surprised that a lot of that grass they mow each Saturday is actually in city right-of-way. So that's kind of the case here. So that's all I have, sir. If you'll identify yourself and make your presentation again, you'll have 5 minutes, and I'll keep the time when you begin.
Thank you. My name is Jeff Woods, and I'm the owner of 4501 Dakota Avenue. And the thing here says side street setback, and as he said, 6 inches. And I saw some of your faces go, well, that's probably not right. It's actually the property line setback is what we're trying to build close to. From the street to the side of the existing home there, it's around 50 feet, 40 to 50 feet, somewhere in there. So I think we already comply with the street setback that exists there. But what we're looking to do is build close to our property line. And I sent in other photos of the like the rendering that I made, and I also drew a property. If you go to the corner picture, yeah. So our property line is kind of where that tree is in the front yard, and it kind of runs, down the side to that other tree in the back, where you see that structure right there. So that's our property line right there. So we're trying to build 6 inches up to that because it's 14 foot 6 inches. And so the building we're trying to construct is a 22 by 14 foot sunroom with a wraparound porch. So the porch would actually come to do a hip corner there at the front of the house with the existing porch. And that I believe was a 7 by 22 porch. So I don't know if the verbiage there, if I didn't understand what was being presented and things like that, but that's kind of our case.
And you put a line drawing in our packet that has, an orange line that I think really nicely shows what you're trying to do and how close
there's an
you'll be.
orange line for the building and then a red line for the property line that I drew.
Okay. Questions?
In feet, how many, how far into the setback are you?
From the street?
No, and how far are you encroaching on the setback, or how far into the setback are you?
So I think the setback for a property line is 10 foot.
Okay. And you're right on, so you're 9.5, okay, that's my question, yeah.
Okay, yeah.
But your setback that you're requesting is 6 inches, that's right?
And then, but the sunroom is going to be part of, maybe take up half the back of the house, and then you're going to do a wraparound porch to connect to the other porch. And that wraparound porch isn't as close to the property line as the sunroom. It's just a sunroom that's on the back. So it's not an addition that'll be the length of the home.
Right. It's just and if you need to see that picture, I have it on my phone. I can.
We've got it. We got it.
Okay.
No, I think we have that drawing.
Okay, cool.
I just was stating it for the record and just to make sure
Yes.
What do you know what kind of overhang you'll have on the front on your sunroom addition? It's got a gable and it's going to stick out a little bit in front of the wall. What kind of overhang do you have there? Because what I'm concerned about, and before you answer that, is that you'll have a permitted setback obstruction is the overhang, but you don't want to overhang into the right of way. So 6 inches may not be enough. I'm just curious what your plan there is.
You mean on the actual sunroom?
Mm-hmm.
So like the soffit kind of area, things like that?
Yeah, your rake over there.
Yeah. I probably would match kind of the existing home there. I haven't really, thought about all that, but it'd probably be a foot, 18 inches, whatever a soffit would be for the normal house there would probably be the overhang from that 6 foot off the footprint of the yard.
Okay.
Have you talked to an arborist or somebody that knows something about tree roots and things like that? Because it's a beautiful tree in the front of your yard. I assume you're going to do everything to keep it.
Yeah, so when we first got this property, there was actually, there were 4 trees in the property. 3 of them are dying. The one that's in the front right there, we had an arborist come out and they suggested to remove it because it is already dying. The tree limb off to the right that kind of shoots up, that big one, it's already kind of hollowed out and dying. We're trying to preserve it and keep it as long as we can, but we actually would like to plant trees along the easement, but that's another case, obviously, but to get more trees involved. But yeah, that tree right there is what the arborist has told us is it is dying and needs to be taken down. But we're not going to take it down until it's, we see the last of it. Yeah, till it's really gone, because we really do like that tree.
Is there I see you have a 14 by 22 addition for that sunroom. Is there anything magical about that 14 feet?
Well, we were going to do it 18 feet,
Uh-huh.
but after we saw the property line was so close to the house, it was like, well, we can't build in the easement, so we
Yeah.
need to make it, we just went with 14 because it was 6 inches short of the property
Right.
line. So, no, there's nothing magical. We could, put that down to 12 if that helps with the gables and all that kind of stuff.
Well, yeah, and that was my thought there, is that if you're sticking out 18 inches past your setback, then you're going to be in the right of way if you do it 6 inches. So
Yeah.
that's why I'm asking that question.
Yeah, that's something we can easily adjust to following the variance there.
Thank you.
Any other questions?
But you say your hardship here is the exceptional narrowness. What is the width of your property?
I'm not sure the total width of it, but I know that on each side, on the right side of the property, which is the west side, I have 6 foot to build, and where it meets the property line with the easement off the property line. And then on the west side of the property, where I'm trying to build, it's only like 4.5 foot is where I am legally able to build with the setbacks. And I think the house is, I have it written down on there, but I can figure it up math-wise, add them up.
Is the width of your lot, is it narrower than your neighbor's lot, or the kind of typical lots along your street there?
Yes, yeah. If you pull up, yeah, that right there, so I don't know about, like, these lines are obviously to the T of what things are, but like the neighbor in front of us, they have a nice fence. It comes all the way out in the easement. It looks nice. There are other properties that have wraparound porches that are a little bit bigger, and sunrooms that we're trying to match that style of the neighborhood, so.
Okay, but.
I'm not sure.
Yeah.
Looking at this, it looks like it's normal. It's a
Not
normal.
Okay, thank you.
Any other questions? Did you have anything else to add?
No, sir.
Mr. Chairman, I'd like to add, this is Sylvan Park, not the nation. So
Yeah.
I don't want to start a
Sylvan Park,
West
okay.
Nashville feud between those two areas. So I was corrected. That
Okay.
Sylvan Park.
People might have taken offense at that, but.
All
don't know
right,
if I
thank
should
you,
speak up
and
or
we
not.
will close the public hearing. This is not an unusual case, and we hear these quite a bit. It is something that, I think that the odds, folks have said sometimes, well, maybe we'll expand the street, but, you could expand this to a 4-lane street and still have 10 feet between him and a sidewalk, and still have the effective setback between him and the property. I worry a little bit about the overhang. I'm not too caught up in what the setback should be, as long as the eave doesn't extend into the right of way. So if he,
Yeah, I guess that's a question for Joey. Is any permitting process will take that into account? Is that correct? Regardless of where the setback is.
It would. We would not allow him to encroach into the right of way.
Okay,
So he
even
would
with
have
overhang.
6 inches to work with, and that would be
Okay,
it.
all right, thank you.
so I don't really have an issue with.
Yeah, I agree. I really don't have an issue with it. I'm having a little hard time finding the hardship, but I think it is a very unusual lot characteristics to have that giant right of way right there.
I think that's it. It's the characteristic of the lot, and yes, somebody to mow that much city property forever, and maybe they should be able to build a little closer to it than they're supposed to. But I don't have a problem with it. And any other comments? I'll move that we approve the variance based on the shape of the lot, the nature of the lot, rather. I'll say the nature of the lot. Any discussion or amendments or thoughts? All right, anybody, all in favor, say aye, raise your hand. Any opposed? That motion passes 6-1. Next case.
The next case is case 2021-135, Smith G. Studio, the appellant, St. Joseph's Properties, LLC, owner of the property located at 1302 and 1308 Dickerson Pike, requesting special exceptions from height control plane, rear and street setback requirements in the CS. And members, I made a mistake on our agenda. There should be the landscape buffer yard too. It's part of the rear setback ask in this. To build a 6-story multifamily building in the CS, UDO, and MDHA districts referred to the board under Section 1716-090F. The appellant has alleged the board would have jurisdiction under Section 1740-180, Item C. Council Member Parker is present. Do you wish to address the board now or wait till whenever?
I'll wait until after the presentation. If that's all right.
Great. Okay, and we do have opposition present. I've spoken with them. If the appellant is present, if you'll come forward, sir, I'll go through the case. You'll have 10 minutes. Opposition will have 10 minutes. Mr. Morton, if you wish to save some of your 10 for rebuttal, you may. Again, I'll keep the time over here. Feel free at any time ask me. If I see you look over, I'll hold up what we've got time left in our. The subject properties in question are these two parcels here, this parcel in the corner and parcel 101. These parcels will have to be combined as a part of this, were this successful today. But it is in the CS district. This is just north of Douglas Avenue and Ligon Avenue. And I raise this distinction at this point. That is the end of the urban zoning overlay right there. Everything south is inside the EZO. Everything north on Dickerson Pike is outside the EZO. An aerial photograph of the subject property located here. And this is the proposed site plan is submitted by the appellants. Again, special exception for height, sky control plane, reduced setbacks in the rear, street setbacks, and reduced landscape buffer along the alley on the property there. This is looking into the subject property. Currently, a auto sales and repair business on one portion of the property. The other portion is vacant. I believe used to be a mobile home sales lot. And then views looking south across Ligon Street, south on Dickerson Pike. Another view south there on Dickerson Pike. These are the elevations and exhibits submitted by the appellant. The portions of the building that violate the sky height control plane along Dickerson Pike are located here. And then views of the side portions of the buildings located here and here. And that is everything I've got. I will leave it on this screen, and I'll turn it over to you, Mr. Morton. You'll have 10 minutes to present. Again, save some time for rebuttal should you wish to.
Yeah, if you would name and address, and then tell us about your community meeting.
Yes, sir.
So don't mess up
Scott
this.
Morton, Smith G Studio, 602 Taylor Street, Nashville, Tennessee. Good evening, good afternoon, commissioners, and thank you for being here. Appreciate your service and look forward to talking to you today about this opportunity. The project is seeking relief through a special exception for several bulk standards, as was mentioned, to bring the property more into conformance with appropriately designed urban building and more consistent with the policy objectives for this area. There was a community meeting held for this property. The most immediate neighbor is the Highland Heights Neighborhood Association, which is board president is represented here today with a council member. They are directly across the street on Dickerson, so abutting or adjacent to the site on the eastern boundary, and they're the most affected neighborhood group. On the western side of Dickerson, there's no organized neighborhood group, and there's a mixture of single-family, duplex, industrial against the Ellington Parkway corridor. The community meeting I was out of town, so one of my colleagues represented us for the project at that meeting, but what was conveyed to me was that generally the information was conveyed from a design perspective. Everyone, I think there's been, from what I just spoke with the neighborhood board president, what was relayed to me might slightly differ from his testimony later, so I won't attest to that, but generally speaking, what was conveyed to me was that there was concern about the property and primarily the land use. And the concern was that this project would allow for short-term rental use on the site. The current zoning today is CS. And I think the concern there is that if short-term rental were allowed, then these requests that we have before you today would extend or the intensity of that potential through these exceptions. So I'll let them speak to that as far as from their perspectives and unique comments, of course. But so with that said, we are Zone CS. We are applying for a special use that's permitted with conditions within the existing zoning of commercial services. We're going to apply for a residential land use here in a commercially zoned district. This is allowed through a zoning condition called the adaptive residential provisions, which allows for, it encourages residential development on these commercial corridors if it meets certain conditions and criteria. We are able to meet all the criteria of adaptive residential, and that's part of the reason we're here today is some of those criteria. It also allows us for some relief through the adaptive residential through a special exception at the Board of Zoning Appeals for certain bulk standards. So we're here for relief from 3 specific bulk standards. The use in question, the property owner has not determined the specific end use. They have looked at this property and we have designed it as a residential structure. The ultimate tenant has not been determined at this early stage. It could possibly be short-term rental in the future, and the property owner does not necessarily want to limit his options from a zoning perspective on the property. Given that the residential use and a short-term rental use is allowed today, they would like to extend those flexible options in the future as they move forward in the design process. So some of the constraints on the site, this is kind of unique in the sense that the property is not in the urban zoning overlay, but abuts it directly. It's just south of us on the adjacent property. Typically, outside the UZO, we would be coming before you for hardship for a variance. However, in this case, it's a special exception because it is utilized through the adaptive residential provisions, which qualifies it for a special exception. But with that said, there are hardships and constraints on the site that are dictating the design conditions for the property and for the proposed plan. Primarily, the existence of existing overhead power lines along the Dickerson corridor adjacent to the property. This creates conflict with us, the ability for us to meet current NFPA fire code requirements for the construction of buildings. We're currently not allowed to build a building against those power lines on the front and allow for fire access, so we have to provide fire access from the rear. I'll get to more details on that in a moment. Secondly, the unique shallow nature of the site. The site is existing conditions is fairly shallow and has significant topography change across it. The alleyway that runs behind it is approximately 10 to 12 feet above the grade along the Dickerson frontage. In addition to this existing shallow depth, there's also a right-of-way dedication that's required by Metro's major and collector street plan to make future transit improvements and roadway improvements and sidewalk improvements for the corridor. That dedication is 15 feet, which is a fairly significant right-of-way request. So that's 15 feet on each side. It's a total of 30 feet in totality for the corridor. So this property would be dedicating 15 feet of its front property adjacent to the Dickerson corridor to accommodate those future improvements. As such, the policies with both in place, which the T4 Community Center policy, as well as the special policy, which is the Dickerson South Corridor Study, has recommended for higher density residential and more intensity at this location. The recommended heights that we are proposing at 6 stories is consistent with the heights recommended per the policy, and our goal is to, through these improvements, to further the policy's objectives as we move forward for new development in the area, to support the growing industry and many of the major investments that have been nearby in River North and in the East Bank as well. So the overall design perspective, we still have a shallow setback. Our height is at 6 stories. And, the density is also a question that comes into mind, which the policy supports here at this location. And our opinion is the density that we're proposing and per the policy recommendations would help to create more housing choices in the neighborhood as well through different building product types and unit types, and higher density to serve this future mass transit corridor and bus corridor.
Mr. Morton, you got about 2.5 minutes.
Okay, I will wrap up then and reserve 2 minutes for rebuttal, please. I would say in conclusion, happy to answer any questions you might have specific to the request. On the special exceptions in detail, I have a lot more information if I had more time, but I do respect your time as well. Our request, we do understand we're in a unique situation where we have some opposition from the area council member, which is never something that you want coming before a board of appeals like this, of course. The applicant, the property owner does own the property and is not here today because of an illness. He was hoping to be here to present with me, but is not able to speak, but wanted me to pursue this forward and get the board's opinions on our request, and I look forward to answering questions you might have. Thank you very much.
I've got just a few questions. I didn't, just on the surface of the proposal, didn't have as much of an issue with the control plane and positioning of the building on Dickerson Pike as much as I did the rear setback request and the landscape buffer. And, if that's, it looks like you're coming in off that alley and also off a light Ligon Avenue. And it's hard for me to judge whether or not it's going to meet the criteria of a special exception in terms of impact on, the surrounding properties without having a little bit stronger sense of what it is going to be used for. And you said that you really are not sure at this point. In the sense that you want to keep your options open for short-term rental, that, this is a preliminary plan. And I think that's what I heard. So if you meant something else, let me know, or if it's more concrete than what I got the implication of, let me know. But having that alley so close to the, having that alley tighten, again, without knowing, exactly what it is, it causes me a little bit of pause.
Sure. I could answer a little bit about the details of the alley and the fire code. And just to, again, from our request today, and you are correct, Chairman, that we do not have any zoning-related requests today. What's allowed by right today within CS is what we are seeking to maintain what's allowed in the future. So with the alley, the NFPA requirements, when you have the existence of a power line, you are required with a building of this type to provide what's called aerial apparatus access, which is a fire lane of a width of no less than 24 feet in width, and then your building must be located adjacent to that. And so our alley condition is currently constrained. The existing alley is somewhere between 12 and 15 feet. I can't recall on top of my head, but we are making right-of-way dedications. I believe somewhere between 5 and 8 feet to widen the alley so that it can serve as a fire apparatus access lane so that they can treat the building with their ladders from the rear. Because the fire code will not allow them to put a ladder over a charged power line, which is the Dickerson, would be the preferred ideal condition. In this case, so we are widening the alley on top of the right-of-way dedications along the front. It creates a very specific depth that now only fits the exact dimension of what we're proposing for our parking to support the project. And so the parking itself is the area that's really in question. We purposefully placed the bulk of the building closer to Dickerson to relieve some of the adjacent context of the tower from the alleyway. And lastly, given the change in topography, the new development that's adjacent to us behind the alley is a significantly higher. I think there's a graphic in your packet that shows a section that demonstrates that the top of the buildings that are going up the hill towards Fern Avenue, that those existing buildings will be taller than what we're proposing on Dickerson based on that grade change. And lastly, I would say, we are open to design considerations and revisions on that rear for the tower portion if there needs to be additional relief based on the context. Our significant constraint is the parking layout. So the ground floor, the one level podium that would be adjacent to the alley is our one limited design condition from a dimensional need. Above that, that can be revised to reflect a number of different layouts.
So on this drawing right here that we see on the screen, there's a building footprint that goes on to Ligon. That's not the tower, right? The tower is just on the front.
Currently, the tower is an L shape where the longest length of the tower is on the Dickerson frontage. The narrowest L-shaped portion on Ligon extends to the rear of the property. That portion of the building, if it was deemed appropriate by this body, can be, stepped back if need be. Our constraint is really what's below it, the podium parking levels, which you can see better in the site section provided. There's two levels of parking that are at the lower levels.
Okay. I guess I don't see any side section that shows that L-shaped tower. I see let me see, yeah, that's the side section.
So on the top right, where that section's cut, it was just cut in the center of the site. So on the top right, if you were to cut that along the Ligon frontage, that tower would extend to the rear of you see those two levels of parking structure, which are the widest rectangles on the bottom. That tower currently is drawn, the short end of that would extend all the way to that edge in this diagram.
Why doesn't it on this diagram?
That's not where the section was cut on the when you draw it. It's in the middle of the site. Because that's the predominant location.
All right. No, I get it. I just, when I'm looking at how does it compare to the houses behind me, and I see the drawing right there, I think, well, it doesn't compare at all. But then when I know that building is going all the way to the end, I was like, well, yeah, it does compare a lot. On that side of the building, it's 3 stories taller than the houses behind it. Is that correct from architects? Now, the middle part where the swimming pool is and all that, that's 2 stories lower than the houses behind it. But that right side on Ligon is 3 stories taller. And I think I get, you guys get it, y'all do it all the time, but this reads as misleading to me, not intentional, but it is not reflective of what's actually happening.
Yeah. Sorry for any graphic confusion on that part. Perhaps it should be dashed in to represent the full spectrum of the building's conditions, of course. And, the policy does recommend higher density and taller heights for those properties to the west, as well as the properties to our south are recommended for 6 stories and 12 stories respectively. So the existing conditions with the 3 and 4-story duplexes on the hill may not be necessarily reflective of the policy's direction as well.
Well, and the ones that the duplexes that are built going up the hill do abut the amenity section, what we can see aerially based on what you, and so I do see that, but sectional drawings don't really reflect that Ligon side. And that was just, I just want to make sure I understood exactly what was being built and where it was going to impact, which I think I do now. And are there any other questions? Mr. Laws, did you have a question?
Just so I will know, it's going to be mixed use, correct? Kind of, sort of. You don't know
Possibly,
what it's
yes.
going to be. It's
It
just
could
going to be a
have
bunch of concrete, glass, and steel.
the ground floor. The intent is the ground floor will be an active use. It could include some active commercial on the ground floor, or it will have a residential lobby and other amenities that activate that street frontage and public realm along the Dickerson corridor at the back of that wide sidewalk.
Okay. So, all right. I'll wait and just ask the opposition a couple of questions. I think I might.
All right, thank you. Any other questions? Seeing none, at this point, we'll have the opposition and/or the council member to speak, and they will have 10 minutes. Actually, so you'll have as long as you want, council member. But as per our rules, the rest of the opposition will have 10 minutes, and regardless, outside of any questions that we may have. So.
Okay. Well, yeah, thank you, board, for spending your Wednesday afternoon here with us. I wanted to address a few things that have been brought up about this appeal. First, there was a community meeting held. Someone from Smith G had reached out to me and asked, what would be an appropriate venue for that. And I suggested the Highland Heights Neighborhood Association. I thought it was the most appropriate venue, and they did get on the calendar there, and they joined us last month for the August meeting. I think that it is fair to say that the short-term rental question was a big question there was maybe 5 or 6 people that were participating in the discussion and commenting. I think they unanimously were concerned about that. However, that was not the only concern. I think that there was a little bit of hesitation about the density. There was questions about specifically the rear setback, and then sort of the impact on. There are some single-family homes to the south of this, on the other side of Ligon. I think people were concerned about the impact on those existing structures and uses. And to that point, there just really aren't comparable structures to this in the area. It is a pretty significant deviation. Let me see. I think that it's within reason to say that what could be built as a result of these total of 5 exceptions could be disruptive to the existing structures. The alleyway appears to feed almost directly into that neighbor to the south on Ligon's driveway. Considerable traffic impacts, I would think. There is a light there, thankfully, at Ligon and Douglas and Dickerson. But I think that it's fair to say that will be probably a negative impact on that resident. Now, how severe is that, and how much would we weigh that? I'm not sure. Ultimately, I think that one of my big takeaways from the community meeting was, we did expect some feedback. Even if that's a list of, you all brought up this concern, that concern, and we're not going to do anything about that, and we don't care about that, and we don't share that concern. We didn't get that any sort of follow-up feedback, which is, I know that the community meeting is a requirement for these exceptions, but I think it should be an opportunity for feedback more than just like a box to check. And so I do think that that's super important, and I hope to have that in the future. Let's see. I had some other notes. Yeah, so I understand the desire to seek additional bulk entitlements, or however I know they're not, these are explicitly not entitlements if I remember correctly from the code, but I understand what they're trying to accomplish here. Policy does support some additional density in that area. I'm more than happy to work with the appellant on getting there. Policy does not prescribe the method by which we achieve those ends. So, obviously this is an avenue that's available. I think it's the least expensive avenue that's available. It's possibly the quickest. I think it is the quickest. But, for a project of this scale, I think that difference between a BZA application and a zoning application is $1,350, which is a very small amount of money when you consider what's being proposed here and what it would cost. So, that's what I wanted to share with you all. Do you have any questions for me?
So I guess that what I'm hearing is that in concept, it's not way off base, but in practice, it needs, in your opinion, to be more compatible with the neighborhood, needs some additional thought and work in response to neighborhood issues and concerns.
At least, yes, sir.
And then, because I know the planning, we have a recommendation from the planning department that, in their, that they said to approve it because in their opinion, it meets the, kind of the big picture guidelines. And then we always like hearing from the council member to say, well, yeah, it might fall into those categories, but in my district and in my neighborhood, here are some of the issues that we have. And so I do share your, I appreciate your comments. And I know that there was some discussion, apparently, that the applicant mentioned about short-term rentals and use, and that's certainly something that we could have as a criteria of any special exception, as it may or may not impact the neighborhood. But are those the types of things that you would want to negotiate and, try to figure out a path that's at least more acceptable to you and the neighborhood, along with planning and the developer?
Yes, absolutely. I mean, those are things that I would like to be addressed or have more clarity on, at least, before certainly lending any support. I mean, at this point, I'm not in favor of these 5 special exceptions. And as you said, I did read the planning report as well. And, I think that planning, they do a really phenomenal job of, taking a parcel and looking at the policy and seeing what is appropriate for that parcel and that policy. And then I think I see my job as more knowing, what is the context. So I'm not looking at that parcel, I'm looking at that neighborhood, I'm looking at the businesses and the people that are there, I'm looking at the buildings next to it. So, I mean, they do just a tremendous job with policy and a particular parcel, but it's, as I said, my job is to sort of know other context and provide other context. So I'm trying to do that here, as you said, and I appreciate it.
Other questions for the councilman?
Mr. Councilman, clarity was the word you used, and what I didn't hear from the applicant was clarity. I heard trust us, what we're going to put there, and you've got livability. I mean, this is a huge project. It's not a little bitty thing. You got livability, walkability, my favorite, trees, but I've got no clarity to try to plug it all back in, and I think that's what you're sort of alluding to, and I want to make sure I'm on the same wavelength. And there is change, but you know your neighborhood a whole heck of a lot better than I do. And can you help me with that? I'm also a little bit concerned with access for fire. I mean, you may have to do a few things on the back, but if you're the one person that needs to get the heck out of the building and there's no room to get you there, that's a real huge problem for you maybe, and it would be for me if I was that person. So can you maybe address the livability, walkability? Commercial is great, but I don't want to live in Manhattan. That's the last place, unless I was right on Central, that, and I don't think that's what any of us want, and help me with it. What would make it better clarity?
Well, so for me, I definitely appreciate what this plan brings in terms of, the walkability. I think that's something we're really looking for in Dickerson. As y'all know, we've had a really unfortunately high number of pedestrian collisions, and so anytime that a project, is contributing to a safer environment there, I'm appreciative of that, and I definitely am in this case. But then we come to the livability question, and again, the lack of specificity. Maybe these are going to all be, wonderful long-term tenants, and there's going to be a bakery and a coffee shop, and it's going to really contribute all this wonderful stuff to the neighborhood. But we have very little specificity about what the potential commercial component on the bottom would be. if any of these would be actually residential units, I think there's just such a broad range of potential impacts on the neighborhood and specifically the adjacent properties that it's hard for me to get to a place of comfort and of support. And I also very, very concerned about emergency access. I mean, I generally, because I'm not an expert in that, I trust the plan reviewers and the codes people and the fire marshal and those folks to get that stuff right. So one of my big things that I always get concerned about when we, and I appreciate what MDHA is really pushing for here with the skyline development standards of, pushing access to the rear of buildings. I think it really does help contribute to the walkability, but I do think that it can sometimes cause, I have heartache about, real world traffic patterns these days, with rideshare and those drivers not being trained or regulated in any way and sort of, doing patterns of driving and of loading and unloading passengers that can cause weird, unpredictable types of congestion and whatnot. And I think that I like to see when people make some provision for preparing for that sort of unpredictable level of congestion around ingress and egress points. And again, especially if you have, there's going to be more of that if it's all short-term rental, right? So if nobody drives and lives there and knows where the entrances and exits are, if all the traffic is coming in through the rideshare, that concern becomes elevated. And again, I can't really weigh it because I don't know what is being proposed here.
So, Councilman, what would be your preferred outcome today? Deferral to discuss it in more detail? Something else? What is your preferred outcome?
The sense, well, I don't think, to be quite honest, I don't think that a lot of the concerns that I have and that my neighbors have can be addressed through the BZA process. So I'm not sure. I mean, perhaps the applicant can speak to how some of those concerns could be addressed, but I think that all that's really before the board today is, are we going to bump up the bulk standards for this property? And I don't think that we can. Maybe I'm wrong. Maybe the zoning administrator or someone has creative ideas for conditions that would give us more comfort. Maybe it's worth deferring and just giving it another try. But my preference ultimately would be that we work toward a zoning change for this property.
Well, and what I'm hearing, and I guess what I'm hearing is enough concern about potential impact along with the what some have expressed. I think I've expressed it, and others haven't expressed it, but I know at least two of us are feeling a little bit concerned about the non-specificity, is that the right word? The vagueness a little bit of where the plan hasn't quite gelled. To in my mind, warrant a deferral, but at the same time, the rules allow them to come to our board, and so I don't know that it's appropriate for us necessarily to say until we exhaust all options, or we feel like they can't meet the terms of this special exception, that we propose that they go a different path, although I know that's your preferred path. And so it seems like if this board decided to defer the case, it would need to be with, a best effort attempt to come up with the conditions that would best satisfy, or as best we can satisfy all parties. And then if the board felt like it still didn't meet the special exception criteria, then the next path would be through, for the applicant, would be through zoning. But I think we'd have to exhaust all of that first. And so if we were to defer the case, how long, to me, I don't see a 2-week deferral being productive, but maybe the first meeting of November as an attempt to give enough time to address at least some of the major concerns, knowing that if this board usually is somewhat generous on allowing an additional deferral if necessary.
I think if in terms of length of deferral, I mean, I think that I would like to have the appellant weigh in on that, I think, because I think that it's going to be up to them largely to engage with the community and myself and their client, frankly, to determine if there's ways to address the concerns that have been raised.
Okay. And that would give them adequate, and again, to give each side adequate opportunity to express their concerns, but also to develop a response that they each have to the concerns. Okay. Are there other questions for the councilman?
No, I was just going to point out that we did have somebody here in opposition.
No, that's right. I was just wanted to make sure I heard from him. We're going to hear from the opposition, and then we'll hear from the applicant too. Again, not assuming where it's going to go, but just trying to get everybody's thoughts on where it might go. Did you have anything else?
No, sir.
Oh, and for the record, you are Councilman Parker from District 5. I don't think we said that, or I
Councilmember
forgot to ask you.
Parker representing District 5. Yes,
Awesome.
Apologies for not sharing.
All right. Well, thank you, sir, for being here. Appreciate it always.
Thank you.
All right, and now we'll hear from the gentleman that is also in opposition. And sir, if you would just make sure the red light's on and state your name and address and your thoughts on the process or the project.
Good afternoon, ladies and gentlemen. My name is Gordon Stacy Harmon. I reside at 1826 Joy Circle, which is kind of in the heart of the Highland Heights neighborhood. I am the sitting chairperson of the Neighborhood Association. To echo a point that Councilman Parker made, the community meeting participation, they did ask to come. We did grant them time at our monthly meeting to speak, and they presented this to us. But it is a grave concern of ours that the feedback we gave was never responded to. It was almost as if it was, I got to check this box, I did a meeting, here we go. And we cleared that little hurdle. So that being said, in addressing the special exceptions, I respectfully request that you deny these special exceptions because this is what they're trying to accomplish, an approval for these to be able to do what they presented to us. The challenge is that there is no way to guarantee this is what is actually going to be built. And what would be possible with these special exceptions could vary dramatically from what we've been presented. We were presented this particular parcel with 106 or 108 units. If you look at the effective density of that particular parcel, and I know this is outside the bounds of the special exception, but I'll get to why I'm making this point in just a minute, that density is significantly higher than what the Planning Commission and the Dickerson Pike study supports for this particular part of Dickerson Pike. We don't know how many parcels are going to be in whatever building they do as residential. Ideally, a commercial zoning district really shouldn't be used for residential purposes, period. There just are not enough restrictions, there's not enough definitions to give us any kind of certainty of what we would actually see. Now, to get to the point of planning's analysis of this particular project, I do have some contrasting points to bring up. Under the Dickerson Pike study, this particular property is land use policy T4CC. And if you look at that study, a 6-story building height is the max that they recommend for that particular part of Dickerson Pike. And that is true. They are wanting to do a 6-story building. If you look at that policy, it also states that RM40 or OR40A are appropriate zoning districts. What you have here, what we were presented, is effectively RM100, which is, in all essence, what they would prescribe for a 12-story building further up Dickerson Pike. Again, they want to do something like this. We don't know if this is definitely what they want to do, but they want to do it because, or they could be able to do it because they get the special exceptions. And that's why I'm asking you to turn it away. This really needs to go through zoning, period. A couple of other points. The they talk about parking. And if you take a look at this particular drawing, almost the entirety of the portion of the drawing that fronts the alley, if you will, is a parking structure. It's at least a story high off the alley, and then there's a little plaza area that they want to build up there. Again, going based off of what they've presented to us. But if you think about it, with the residential almost all the way up, more than halfway across this property, how are ladder trucks going to be effective in fighting a fire that happens on Dickerson when they have to use the alley and they're a story below? There's too many questions here that have not been addressed. And again, not to belabor the point, this is zone commercial. They're wanting to do something that is 99% residential. It really needs to be rezoned, and I respectfully request you deny these special exceptions so that we can insist they take it through a zoning process instead. Thank you.
Questions for the applicant, or for the opposition?
I at least want to compliment them. I mean, you did your homework before you showed up today. This is just a general question in the neighborhood. Is this area a food desert?
No, actually, right across the street from this proposed development, there is a coffee shop, Retrograde.
Okay.
A couple of blocks up, there's a restaurant. There's places in that particular area.
And I don't want to use a particular brand. Yeah, a grocery store. How about that? I mean, because if you're going to have a large number of proposed residential units and you don't have the infrastructure in the area to feed them, are you really just creating Airbnb?
Exactly. So approximately 2.5, maybe 3 blocks up from this, at the corner of Gatewood and Dickerson, there is a small locally owned grocery called the Uptown Fruit Market. It's basically a mercado, a Mexican-owned grocery. Another 3 blocks north of that, there's I think it's a Piggly Wiggly, or maybe it's a Hills grocery store. So there is food available from a grocery in that particular area, but it's not immediately close to this, if that answers your question.
It does. I think you understand why I'm trying to aim in that particular direction.
Absolutely. Okay. But again, to your point, it's proposed at 108 or 106 units now. There's no guarantee that it's going to be that, because commercial doesn't really have the same type of restrictions as, say, a residential zoning would.
And you, as attending the meeting, have no more clue now, even after attending here, than you did before you went?
The plan that we were presented made it sound like it was a done deal because of the way the drawings were set up, and we were going to have this, we're going to have this number of parking spaces, and people are going to come in from here and there. But again, as you know, with base zonings, especially with a commercial zoning, there's no guarantees. If they were to sell this property after getting these special exceptions, we have no idea what would go in place.
Let me just interrupt just for a quick second and say that part of the thought of a potential deferral is to specify some of those concerns and issues, because it is within this board's authority in approving a special exception to approve a special exception with conditions that are outlined by this board and often are negotiated and presented to us to include. Sometimes we add additional conditions, and also based on a specific plan that is presented to us. And so that can be a guarantee. And so I appreciate the concern for having that guarantee and wanting those things codified, but that can be done through this process. Now, and that's what I was alluding to before. So that is what I would propose in a minute, that we spend some time trying to negotiate and outline more specifically, but that can be done.
So may I ask a question to that point? I'm sorry.
No,
I just want clarity on this. If there are conditions attached to these special exceptions, do those carry forward with any future owners?
The conditions are for that special exception, and so yeah, they would. The conditions are what are going to be built, or what is allowed to be built on that property, and they have within, I think, 2 years to get a building permit after they get permission from this board to do whatever they do, as Joey says at the beginning of every meeting. And if they get their building permit, they build it to that, to that plan, whether they have sold the building and that right to somebody else or not.
My concern would be if you could.
I've answered it, and so, I mean, I know but yes, the ruling here carries through. If they tear down something and build it again, I don't know how that works, but they would most likely have to come back and ask for another.
You're alluding more of if we defer it, right, Mr. Chairman? That's how I was understanding.
No, I'm saying if we do it. He's asking if we pass something and they sell the land between us passing something and something getting built, do they, whoever buys it can build exactly what was passed if they can get that permit within 2 years, or they got to come back and present something totally new. Or they build something fully up to code and they don't come to us at all, in which case nobody has a say other than the owner and the building code folks. So
I guess my big concern, pardon the interruption, is that whether or not this board can restrict usages as part of those restrictions, which doesn't seem to be in the purvey of the BZA. You're only specifically talking about building structures, where my point is, if they take these special exceptions to build this, the usage would still exist, and there's no way for this board to prohibit that.
It's my understanding that there are conditions, and we'll ask our legal counsel specifically what those are as you all decide what, and negotiate what, and you may not come to terms. You may say, I don't want short-term rentals, and he says, I'm not going to agree to that, and we have to decide if that's something appropriate or not. But I know this board has had the authority in the past to say there is a condition that no short-term rentals be allowed. And so additional things we would have to confer with the code staff and our legal counsel. But I do think that we have the ability to put conditions on a special exception.
Okay.
So, sir, what is there? You know this neighborhood well. What is there now? Is this a vacant lot, or is it?
Well, if you recall the initial graphic that Mr. Hargis had up, there's two actual parcels. One is where this auto sell and repair sits,
right.
And to the right, if you're looking at the picture like I am, of that light pole, there's a vacant area, and that's the northern portion of these two lots.
Got it. So, and I totally get your concerns that this is vague and it's kind of half-baked, but is there, if this was done right, couldn't it increase your property values over there and be a good thing? If you got the right conditions?
Until it came time to pay the taxes on them, yeah.
All right.
But in all honesty, the meeting that we had, no one was opposed to the idea of building apartments.
Right.
No one was opposed to the idea of building residential. The problems came into the setbacks, taking it almost all the way to the street, the loss of some landscape buffer, the fact that we're basically taking what little pervious land there is there and putting an entire structure that covers virtually the entire acre, which will only add to the stormwater.
I'm with you on all that, and I understand your concerns. Just to me, it seems like, I don't live in the neighborhood you do, but it seems to me like if you did this right, it might be something that the neighborhood could be a good development.
If it was done properly.
So that's why I think maybe a deferral. I get you're wanting to do the rezoning, but you might, and I do think we can put conditions, and my understanding is they run with the land. They're not just, they don't expire in 5 years, or, I mean, if we put a condition on it, as I understand it, it's there for good, and the neighbors could count on it and take it to the bank, so, anyway.
That's a level of comfort, thank you.
I'm going to ask to hear back from the applicant, unless there's any other questions for this gentleman, and if not, we'll hear from the applicant and get some thoughts and then talk about next step. Joey?
Mr. Chairman, if I could address I think they've hit around it. Can this board restrict land uses on a property that are otherwise permitted in that zone district? And the answer is firmly no. This board lacks that authority to do so. So if CS permits short-term rental uses, this board, in my belief, and I think legal counsel would agree with me, that you do not have the authority to restrict land uses that are otherwise permitted in the zone district. You can put conditions on an appeal, hours of operation, setbacks, you know, it runs with the land, to Mr. Harmon's question. You know, that approval runs with land. But let's say they come before you and they're asking for a special exception on the height. You can't, I don't believe you can then say, well, we're not going to permit restaurants on this property. There's no linkage between those two items. So it's my belief, and I think our legal counsel would agree, that you lack the authority to restrict land uses which are otherwise permitted on a zone district.
Even in a situation where it's a special exception and the criteria that one has to pass is impact on the neighborhood, and to say to, you know, if this board were to say, yes, you would meet all the criteria if you didn't do this, which would impact the neighborhood, you have the right to do this, you will have the special exception. If you were to not have, you know, if this board were to say, you know, and again, it may come down to short-term rentals or not, and that's why it's being asked, but if we said, no, short-term rentals, in our opinion, cause such disruption that this would impact the neighborhood in a way that does not allow you to meet the special exception, if you agree not to do that, we believe you do meet the criteria. What you're saying is that we can't create a situation where they can pass those exceptions or pass that. I mean, because you could, there are things that are permitted by zoning,
right,
that might not, in a board's opinion, allow them a special exception.
I think an appellant can come to you and say, look, we'll agree to, as a condition of our approval, not to do short-term rental. And you can include that as a condition of this board's order. But that came from the appellant. I don't think it can go the other direction, the board saying, you cannot do this use on this property.
Well, or how about if we said, if you agree to allow us to do this, then we think it'll meet the criteria. Because in the way you describe, I mean, nobody's going to come and just volunteer it unless they feel like it's the path to get board approval.
Just one lawyer, one guy's opinion. I think we're on shaky legal ground.
Okay, no, that's fair enough. That's why I'm asking.
Coming from the board's opinion. It'd be akin in the situation if as administrative side, I have a site plan and it otherwise meets it, but, you know, I think, you know, the parking's not going to work, so you can't do bar here. I can't unilaterally say you can't if the zone district permits it. And I think coupled with that, this board can put reasonable conditions on a land use by special exception, but I think I'd be careful to craft conditions in such a manner as to prohibit a use.
Okay.
Through those conditions. So.
Okay, so I think that's a question for our legal counsel for homework, I guess, to say, well, you know, help us when this case does come back. We'll have to have that in mind to say, well, how should we craft it, and what should we be thinking, because it sounds like that's going to be coming up pretty quickly for us. All right, so we'll hear from the applicant, and then and I think at this point it seems clear that enough board members feel like it needs to be deferred and talked more about. And I think at this point it's probably a question of when you would like for us to meet again.
Thank you, Chairman. I think my response is really simple. I mean, I'm a design consultant. I'm representing the interest of the property owner. They have shown that they do not desire to go through rezoning to restrict short-term rental, and they'd like to seek relief from the board for these design regulatory standards. So that is my position to represent. I think that my client would agree that we would be happy to defer the case if there were more to work out. I mean, I'm in a unique situation here that I've never been in before, with opposition of not only the neighborhood president, but also the council members. So not in a good place here, and understand that. However, I think that our differences are more than just design and are fundamentally based in land use. And if that's the case, a deferral, which is more than welcome from our perspective, and we're happy to address any design concerns with the community and listen to more input on the design and take them into consideration and possibly even make revisions to the design. But what I think is, what I've heard consistently has been primarily fundamentally revolves around the land use. And We're not really here today to ask about land use, and I think that the questions about specificity, I mean, it's a really challenging thing to require or to have all the specifics at a very early zoning stage. If we were going through a rezoning and doing a specific plan, we would have a lot more information at this point. There's, hundreds of thousands of dollars are spent producing designs to give the level of specificity that's needed to do that, and people are obviously not willing to do that without some kind of comfort that they have the zoning vehicle to accomplish their goals. And so I think while we may not have the specifics from a design, everything laid out specifically, we've given you, I think, a very clear plan from a site plan, and I think our requests are very specific and are in appropriate format per the regulations that gives the purview of the board to recommend special exceptions. I mean, my challenge here today is to prove to the board that the specific requests that we have given for relief for the rear setback, the front setback, and the height, that they demonstrate that the relief being requested will not be injurious to surrounding properties and violate the adopted general plan. We have, gotten the planning staff's opinion that this is consistent with the general plan and meets the policy objectives for the area, the density. The whole purpose of the initial adaptive residential provisions to be allowed by right in commercial zoning as a separate path. I was actually an employee at the Metropolitan Department when this was crafted at council, and the impetus of this was Rick Bernhardt wanted to remove all the barriers to residential on our major commercial corridors. He said, hey, let's just incentivize it and try to make it by right, give free density out. It basically says as long as you have 40% of your building dedicated to residential, you don't have a density cap. You can build as much as you want up to the height the policy recommends. And the goal was to really promote residential and deconcentrate the sprawling commercial corridors that we have all around our city in Nolensville, Dickerson, Charlotte, et cetera. Yeah. So I think that this plan is consistent with the intent of the adaptive residential program to build and allow residential land uses on the corridors. Like I said, we were happy to defer to continued design discussions, but I'm not certain that is what will produce a different result or not.
Well, and time will be the teller of that one. Yeah. And you may be very well correct, but I do think you've heard, at least from enough council people, or enough of our commissioners, that this, I don't know exactly what you're building. I mean, I know what the massing is, but I don't know, because you said, we're still figuring it out. Fair enough. But I think that and totally fair enough. But it does raise questions in terms of impact of the neighborhood, and so I think there needs to be a little bit more clarity, and I think that's worth the discussion. And I think, it's not a free-for-all for the opposition to say, to hold the property owner, hostage, so to speak, and say, if you don't do all these, we've approved plenty of things that had opposition. We've disapproved things that had no opposition because we didn't feel like they met the criteria. And so what I think we're trying to do is to get a path to do that. This process is a lot easier than the SP process, but it also sometimes requires a lot, more iterations, especially when there's opposition, especially when that's councilmen and neighborhood.
May I ask a quick question related to that, please, sir? If land use is important to make this determination on behalf of the board, I think you could look at this, I'm speculating, but based on the information I've heard, is that short-term rental is not a very desirable use for lots of reasons. On this, the existing zoning allows it. It also allows hotels, which is essentially the same thing as a short-term rental, 30 days or less. In fact, it's got less red tape than short-term rental because you just say you're a hotel and build it. If the problem of our application is related to land use, then I think that it would be easiest we could speculate on a land use. The goal here is to preserve we're not here to ask any land use changes of what's allowed by right, but is short-term rental allowed per the CS? Yes. Is hotel allowed? Yes. So if one of those is considered a nuisance use, I think you could, for the purposes of making a decision, say this is a short-term rental project. Are the requests that are being made appropriate or not, based on that land use? Because it is a possibility based on the current zoning.
Okay, so if you were to, did 2 weeks, I guess, what's the length of time that you would prefer? Your preferred outcome would be we vote for it today, and I don't think that's going to happen. And I think you hear that.
No, my preferred outcome would get the support of the council member, but if whatever, again, listen, we're more than happy to defer to meet with the community. I do not think that's going to happen in 2 weeks. So
at the first meeting in November, if you need more time, you let us know. Is that okay? All right, is there anything else to add at this point today or any other?
I have a question, but I think there's been a lot of confusion today, and I think I heard the opposition say they're not even sure residential will be in this building. But certainly if you're going with the adaptive residential provision, residential must be in the building, correct?
That is correct.
Okay. Second question is, and I wish I knew the answer to this. The councilman mentioned concerns with rideshare, with people just dropping the car stopping on Dickerson Pike and people getting out and it being dangerous. Is there any, I don't see it on here, but it doesn't look like you have on-street parking in your plan.
Currently, on-street parking is not permitted on Lincoln due to constraint considerations. It could be a possibility on Fern Avenue, but it would have to be approved by Public Works. We would be happy to work with both Public Works and the neighborhood about providing space to accommodate a turn-in or a pull-in for parallel spaces to accommodate rideshare, of course. We know that's important.
Okay, and could the pull-in, you're saying it would only be on Fern Avenue? If it could be on Dickerson Pike, could it be in the 15 feet that you're requesting to?
That's a great question, and I do know from precedent and previous many conversations with NDOT, excuse me, I said Public Works, NDOT, that that would not be permitted by NDOT.
Okay, so that sounds unfortunate that they're, I'm saying that maybe the council person can do something about that because it seems unfortunate that wouldn't be allowed. But that's just my commentary.
All right, any other questions? All right, I'm going to close public hearing. I'm sorry. Then, yeah, if you'd have to come up to the mic and.
So I appreciate y'all letting me clarify something. And I know that this whole thing is super duper complicated because of sort of just how complicated the code around it is. So when I referenced, they could use the adaptive reuse, and I thought it was very interesting to hear sort of what the spirit of the adaptive reuse provisions was, and it's, which is the lower barriers to residential. But we are seeing in project after project that adaptive residential is being used to construct commercial short-term rental units. And that was what I was referring to when I said that this project could be built using adaptive residential, but theoretically there wouldn't be a single residential unit in there because every one of them would be eligible for non-owner occupied short-term rental permits. So I just wanted to clarify that and thank you.
I appreciate that because I think adaptive residential, I agree with you. I think the Airbnb stuff is not really what was designed for adaptive residential, but I do think in the discussions about this, I didn't realize that this applicant made a good point, which is it could be used as a hotel right now and be zoned. And I always think neighbors ought to think about maybe maybe what's being proposed might be better than what could be proposed. And it's something to think about. I'm totally with you about adaptive residential. I don't think when Mr. Barnhart and came up with that and it was adopted, I don't think Airbnb had all the negative consequences it has now, so, but for what it's worth.
I'm super happy to look into that on my end. The thing about, just from my perspective as a council member, the hotel versus short-term rental question, they are very different in terms of their impact on the neighborhood. Hotels tend to be staffed. We don't tend to see the disruptive issues with shootings and large parties and whatnot. I just don't get calls from the hotels in my district that have staff, about those kind of unsafe conditions and massive parties, breaking health code during the pandemic. We just don't see that in the hotels. And for me, there's a big distinction there just in terms of how many calls I'm going to get about it. So.
All right, thank you.
Thank you.
I know that we need to wrap up, and full disclosure, I'm super familiar with this area. Up until recently, I lived less than a mile from here, and I grew up over here, so, 30 years over here. I will like to point out that, I've been on the board for 2 or 3 years now. I've never seen a special exception with so little detail. I think we got confused in the arguments about use. From my perspective, that's not really here for us to decide. He's asking for 5 different things, and I don't know what's going here. And so I just think if you're going to ask for 5 specific sort of exceptions, I need a little bit more specificity on the plan. And so I think in the applicant's comments, it was a lot about the use and how another meeting wouldn't really necessarily fix that. It's more of a design thing. I think if you're going to ask for a special exception, I think there should be some more specificity than use other than, well, we have the right to build whatever we want to build. Yes, you do. Then don't come ask for a special exception because you do have the right to build whatever you want to do. So if you're going to submit yourself before this body, I think it's a little disingenuous just to paint this as a use discussion because for me, I don't care about the use because like he said, they can do anything. I am familiar with Fern and Ligon. Those are very narrow residential streets, and it abuts against sort of single family homes. And I just think if you're going to build a larger kind of project, I think you need a little bit more details, and not regarding use.
Well, and I agree. I think that the discussion of use came because of the lack of saying this is exactly what we're thinking, or pretty 99%, 95% close to what we're thinking. So, and I think that was made clear. I'll move that we defer this to November 4th.
Second.
Any other discussion? All in favor, say aye. Aye. Any opposed? We will see y'all in a month. And we will move to our last case.
Okay, Mr. Chairman, our final case for today is case 2021-136. Dwayne Cuthbertson is the appellant. Nicole Tremblett, the owner of the property at 1202 A. Siegler Avenue, requesting a variance in the street setback and fence height in the R6A district to build a pool with a 6-foot privacy fence within the required front setback. Referred to the board under section 1712.020. The appellant would have alleged jurisdiction under section 1740.180 I to B. I know the appellant's present. Is there any persons present opposed to the case? Okay, seeing none, Mr. Cuthbertson, you'll have 5 minutes once I get through with my portion. The subject property you see here is on the north side of Siegler Street, just west of 13th Avenue South. These are recent constructions in the area. The request here is to construct an in-ground pool in the front setback. The zoning code permits swimming pools in the rear and side setbacks as permitted setback obstructions. However, if you construct this pool, be it above ground or at grade in the front yard, we subject it to street setback. So that's what you see here is that treated as the structure. So they required a 32-foot street setback. They're requesting a 5-foot setback and also a variance request in the 30-inch opaque fence height within the first 10 feet. They're requesting a 6-foot tall fence within that 30-foot space. This is the view of the front of the structure. The pool would be constructed in this area, and then fence would be located along the sidewalk, views up and down the street on both sides. And this is a rendering submitted by the appellant. This area over here, this green area is not grass. This is the road. This is where the street is in this. Kind of the perspective from, he used green, and I appreciate that. Maybe just didn't, but I didn't want it to fool you that that's just grass over there. That's the road. So he's proposing some trees to screen the fence, which might be an issue with Public Works, but not inside the zoning code, but the fence itself is in violation and this pool would also be. So he's requested those variances, and I'll leave it at that. That's all I've got, Mr. Cuthbertson. I'll turn it over to you.
Members of the board, Dwayne Cuthbertson, 409A Merritt Avenue, Nashville, Tennessee. Mr. Hargis, I appreciate that clarification. I'm certainly not proposing to green the streets, although it's not necessarily a bad idea. Not in this case. I am representing the owners of 1202A, Sigler, Nicole Tremblett, and her partner, Ollie. We're requesting that variance to permit a small pool, a 10 by 28 pool in the front yard of this R-zone property, and then we're asking for a variance to allow the required security fence for the pool in that first 10 feet too. This property was developed prior to the current owner and set up as a front-to-back configuration, as you saw on one of those site maps. The applicant owns that front house, and as seen on the site plan, it's a relatively small lot, and the only outdoor recreational space afforded to this owner is that front yard. There's a small space in the back corner, but that's a shared space that also has the pedestrian access for the rear homeowner to the street. And so this is the only space that they're afforded to use for recreational purposes, backyard, front yard, you name it. So the code's intent, I think, is to limit pools' locations. Is likely rooted somewhere in tradition. You know, if you think about a pool on a residential property, where does it go? It goes in the backyard. And so I want to believe when the authors of the zoning code were creating setback obstructions and they thought of pool, well, it's just an automatic trigger. Well, where do pools go? They go in the backyard. They didn't think to caveat that restriction with unique conditions that might be applied that would allow pools elsewhere on the property without necessarily impacting the residential character that this code also attempts to establish, preserve, if you will. As you'll note on those aerials, this property is located in a fairly untraditional urban setting. You've got condo buildings, apartment buildings, all around this property. You've got townhouses that are built right up to the road just to the west of this property. And then even on this block, while you have two families, many of them are short-term rentals, these two are not, you've got varying treatments of the front yard. Some of these front yards are entirely paved and parking areas. So I would argue that there isn't a traditional residential pattern in this neighborhood. So we've got this recreational space, and in an attempt to use it in a manner afforded to us, we're proposing this pool, if you will. And again, it's just a small pool. It's a 10 by 28. More importantly, and I think what I want to focus the board's attention on, is we are proposing a landscape screen in the front yard. So while it doesn't appear so in this image, the intent is to provide a consistent landscape screen around the perimeter of this recreational space, one that ultimately would be opaque. It would be of the evergreen variety. And so the intent is we put this landscape screen up, and from the street, from the sidewalk, you can't see within this space, this recreational space for this front yard. And so that landscaping is allowed by right. They can put that landscape screen up tomorrow. And it's in the middle of a block. It won't block any sort of visibility. The parking's all in the rear. And so I feel like putting up this opaque landscape screen fence or screening it would happen tomorrow, and nobody would ever know what was behind there. So the zoning code allows you to use that space in a variety of ways anyway. You could put up art sculptures that could be offensive to neighbors. You can use it as recreational gathering spaces. You can put a fire pit in there, a small pond in there today. You can put up tables and chairs and host picnics and parties all weekend long. We are asking for permission to put a small pool in that same space. Any thought that it would disrupt some traditional neighborhood pattern, we feel like is mitigated by our proposed landscape screen. And so that's what you'll see from the street, not the pool or the recreational space that they're proposing to use there. So it's a unique request, I admit. And so when the homeowners first approached me, I thought, well, the first thing we need to do is talk to the council member, talk to neighborhood association, and then your immediate neighbors. And we've received nothing but support from the council member. You have an email, it doesn't say, hey, I'm all for this, but he didn't have a problem with it. He pointed us to neighborhood leaders, and we reached out to them, and
Your time's up, sir.
Joey, do you have a street view?
I do. If I can figure out how to turn this thing on.
Which one it is? Okay. Thank you.
so I think I'd just finish by suggesting I hope that you find our unique treatment acceptable and find that our use of the recreational space is approvable. And I'm going to give you some emails of support that we received that might not have made your packet.
Question?
I just had one question. So I really understand everything that you said. Thank you for all of that background. If you were going to articulate a variance for the request, like the hardship unique to this property, what would that be?
So it's hard to articulate, for sure. I think the hardship is somewhere in this idea that the authors of the code can't write standards for every situation. And so they allow some recreational uses in this front yard, but specifically said pools only in the rear yard. And I want to believe that that's just an automatic trigger. And they couldn't then caveat the code by saying, well, hey, but if you put up a landscape screen and nobody can see you, then we'd be okay. And I think that's where the BZA comes into play, and that if we can create those unique circumstances, in this case with that opaque landscape screen, you might find that unique enough to support
But not only behind the landscape screen is the pool, but it's also a 6-foot fence where a 30-inch fence is allowed.
Correct, and we're required, because
So,
the
I mean,
pool.
you're asking us to
Yeah.
find a hardship that changes the fence, the front yard fence code and not the landscape screen code, because you said that's by right, fine. But to allow a pool, because, and the hardship for the pool is it's the only open spot on the land, but then it requires a fence, and so the hardship for the fence is that, well, it's the only place I could put a pool, which isn't really unique to this property. I mean, I guess when I see it, do I think it's, would it be a horrible thing from a neighbor to have? Probably not. Do I think every duplex in this town that's built front to back is going to want to come to us and ask for a pool, and should it be handled another way? Absolutely. Because it's, I mean, that's just my gut, is to say, there were so many choices that were happening on this piece of property that caused this to be the only spot that pool could go, that says, and yet at the same time, I see what you were trying to do, and if I were a neighbor, it'd be like, looks nice to me, maybe I'll get to swim. I wouldn't be, or not, or, it would be perfectly lovely, but like I said, I'm having a tough time with the hardship that's unique to this property.
And I can appreciate that. In fact, we did get an email of support from the immediate neighbor. We proposed a 6-foot fence. The 6-foot fence is triggered by the pool. If a 4-foot fence it meets code, then they'll do a 4-foot fence. And I think, again, the idea is that fence would not be visible either. So you see the landscape screen, and you don't see the fence, you don't see the pool. If we had room, we'd bring that fence back 10 feet from the right-of-way, and we could build a 6-foot fence. But this is a very shallow front setback, and I understand your point.
Right.
They built it out that way. I'd also say this is it's a somewhat unique urban neighborhood. If this were in Bellevue and you had 20 front lawns, 30-foot setbacks, that's a different story, I think. And so I hope with our treatment and our context, you might find this one somewhat unique.
Any other questions?
Yes. Is this property used, or is there intent to use for short-term rental?
No. Nicole bought this property, I don't have the record in front of me, it was a few years ago. It's her home.
Okay.
She lives there.
All right. And the reason I ask is I just imagine you have a pool in the front yard, you have a short-term rental property a block from the Gulch, you have big parties, and it's a big nuisance for the neighborhood. That's what I wanted to ask about.
I
Okay, thanks.
get that one. And it's a two-family, and Mr. Hargis, correct me if I'm wrong, I don't actually know the rules anymore on short-term rentals, but I think you have to own both, and then you can rent one of them, but they're two separate owners. Nicole owns the front one, and I don't know who owns the back one.
It looks like in this picture too, there's 4 pretty mature, some kind of hollies. I guess those are coming out.
Those are going to have to get transported, or they're coming out and getting replaced. Yes, sir.
But those are arborvitae, and they don't last 10, I mean, that's not a tree that's going to last very long anyway.
We are definitely.
Well, I agree, but I've had 20 years of arborvitae that I've replaced 3 times because they grow so big, then they fall over. It's not a long-term tree. So please, let's don't get caught up in those 4 trees right now. I know. Wonderful friends across the way over there. Awesome. Any other questions right now?
Dwayne, I'm looking at the picture. Looks like you've got. Do you have both water lines for both units up front, and how are you going to?
Yeah, that's a water tap, and so they're definitely going to have to work around that. And if they want this, if it's granted today,
I understand, but
and those meters are in the way,
they got a real problem.
They're going to have to either move them, or they may not be able to do this. But they're going to have to work around those meters for sure. And that's about the only corner where those can go, because that service line has to run up
on the other side, too, yeah.
Yeah.
And I'm assuming it's a gunite pool that you're putting in. Do you even know? I mean, it doesn't matter.
I don't know the answer to that.
Okay.
They've spent a bit of money working with an engineer on the front end. I don't suspect that they're going to do something cheap. Okay. But I don't know the answer to that.
Okay. Any other questions? Anything else to add?
No, sir.
All right, we'll close public hearing. I said my thoughts, but what else? Any other?
There's no other place to put it. It's a huge investment. I'm a big pool person as well as a tree person. And it increases the value. So as a taxpayer, I much prefer to see that happening some places. And they've thought it out. So, and there are hardships there. I mean, it's a bizarre lot.
And I mean, I agree with all that, but the hardship, which I think is, again, based on the choice of.
Is it self-imposed is the question I have.
Well, maybe by not, but, it is definitely imposed by the choices that have been made on that site, and that's where I am. I don't, as much as I think it would be nice, I think that this is not an unusual situation in this town now, houses like that. I think we'll be asked to do this all over, and there will be situations where it does, I mean, I think it's a can of worms without a hardship that's unique to this property, but that's just my thought.
Well, I think it's a can of worms too. I also think it's going to change the view from the sidewalk, because I've walked on sidewalks along where you have, I mean, all of a sudden you're going to have open yards, and then you're going to have a fence, and you're going to have, and the 6-foot fence is a big ask too. I mean, because it's a 30-foot fence variance or requirement. So I think it's a very nice, and the people put a lot of thought into it, but I can't go there with it. I'm sorry. I'll make a motion to deny the application.
I second.
Have a motion, have a second. Any other discussion? All in favor of the motion, say aye, raise your hand. Those opposed to the motion, that motion passes. Good luck, and we adjourn. Got to run late.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.